Do 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 do. 339 Canton time. Jackson, United, it's time to shine. There's snow, there's snow, there's snow, there's snow. To the window, to the wall, to the wall, to the bartender's last call. At the waterfall. Ah, sleep, sleep, motherfucker. Ah, sleep, sleep, goddamn. Ah, sleep, sleep, motherfucker. Ah, sleep, sleep, goddamn. They'll crunk and act and meet. Rhymes will be wrestling, have too much drink in their minds. Everything's fine, but an act have already gathered about 50 damn times. To the window, to the wall, to the wall. The bartender's last call. At the waterfall. Ah, sleep, sleep, motherfucker. Ah, sleep, sleep, goddamn, goddamn. Ah, sleep, sleep, motherfucker. Ah, sleep, sleep, goddamn. Do, 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 do. Hello, everybody. Welcome, welcome, welcome. We've got a lot to catch up on today. As per Karen Reed, we're going to go over the latest court filings as well as watch the hearing from today. But I thought first, let's just get a little warmed up with this video for you guys. Many of you guys probably haven't seen it. And if you have, either way, it's freaking hilarious. So this is just a it went, I think, semi-viral, at least in terms of people who watch depositions. I love watching Trainwreck depositions. Shout out to Kid Smiths. I was just talking about you last night, by the way, my friend, because we've got some new squirrel friends who are also from Portland. So shout out to Kid Smiths. But not Glenn, by the way, although, you know, near Portland for him anyway. But yes, so Kid Smiths, have you seen this video? So okay, so this is, you guys are gonna love this. It's not long, but it's really good way to start the live stream. And Kid Smith saying, no wonder I was sneezing so much. There you go. Now it all makes sense, right? That's what we do. So let's take a look at some awesome shenanigans going on here.
We are on the record at 9/6. Today is March.
This is amazing, guys. This is amazing.
12, 2018. This is the video testimony of Robert Abrams, taken in the matter of Justin Markovitz versus Jacob Daniel et al. Case number 17 CD 30522 in District Court for the City and County of Denver, Colorado. Today we're located at 110 16th Street, Suite 1400 in Denver. I am the videographer, Tim Dior. The court recorder is Divine Basinger. Will all attorneys please introduce themselves, beginning with the titles?
Thomas Werge on behalf of plaintiff Justin Moskowitz.
Attorney Robert Abrams, license 37950, appearing pro se.
Neil Sullenberger, attorney registration.
You're like, wait, did my ears deceive me? No, they did not. He said he's appearing pro se.
48698 for the firm.
Will the court reporter please swear in the deponent?
Attorney, ask you to raise your right hand. Do you swear or affirm that
Y'all
the
are gonna
testimony
die.
about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
Thank you.
Good morning, Mr. Abrams. As you know, my name's Tom Werge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit.
Yep.
And do you understand why you've been asked to give your deposition today?
No.
Are you
Yes.
aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
We're gonna do a counter.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
Mr. Abrams, Have you been deposed?
Objective
before?
form.
Objective form, move to certify the question. If you feel that I haven't answered,
Hold on.
then you can move for a
I need
sanction.
to,
We're going to go ahead and stop the deposition at this point.
okay, hold on. So it's already going off the rails. I'm going to do a counter for I don't recall an objective form, but I need to back it up so I can count these. I'm just getting my banner up here. Okay.
And do you understand why you've been asked to give your deposition today?
No,
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial
We're going
next
to come back
month?
to hearing.
yes,
And are you aware that you are a witness regarding the actions of Abrams and Associates?
yes,
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're there.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've
Objective
answered,
form.
I've answered that question. Objective form, move on.
Mr. Abrams, have you been deposed
Objective
before?
form.
Objective form, move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
You guys heard it right. They're calling the special master. This is basically their babysitter.
Off the record.
No, we're staying on the record, please.
Oh my God.
Would you be prepared to read back my answer to the special master regarding counsel's questions
Special
as to
master.
whether or not I answered that question?
What do you guys
Good
think?
morning.
Is the special master going to be available or not?
Could we speak with David Tenner, please?
Let me check and see if he's good. May I ask the caller?
Thank you. Yes, these are the parties from the Moskowitz versus Dahlman matter, and we are in the middle of a deposition this morning.
Okay, hold on just a moment.
Thank you.
He's like, not them. No.
He is not in the office at the moment.
Ah,
Can I get a
there.
number and have him call you back?
Yes, that would be great. If you could please,
Okay, I'll send him an email right now.
appreciate it.
You're welcome.
Bye-bye.
Ruh-roh.
Can we
Mr.
just stay on the
Abrams.
record here?
Yeah, we're still.
Oh, okay.
Yeah. Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Objective form.
Asked and answered, move on.
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not
We're going to
harassing
move for
you.
sanctions
I'm
against
asking
you.
you to.
Oh, I need to make a counter for move for sanctions also. We've got one so far.
You're not
Answer
going
the
to
questions.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer to the question.
So it's your testimony under oath today, Mr. Abrams, that you do not recall whether or not you've ever been deposed before.
Asked and answered. And so please read
You
my
need
answer
to
back.
answer my questions, Mr. Abrams.
Please read the answer back.
No, do not read the answer back, Mr.
Like-
Abrams.
like the
This
answer
is-
to be read
Let's
back.
move on. How many times have you been named in a lawsuit in your individual capacity?
I can't recall.
Have you ever been named in a lawsuit in your individual capacity?
I think so.
Okay. And when do you think that you were added?
IS is asking, what is this? This is just short. It's not long. It's just, we're going to start. Just thought it would be funny to start with this before we jump into Carrie. This is just a train wreck deposition that kind of went viral in terms of the world of train wreck depositions. You don't need to know it. I don't know anything about this any more than what we see in this video. And the facts of the case literally are irrelevant. It's just really fucking funny. And it just goes more and more off the rails as it goes along. Yep, correct. Kid's been saying, right, you supposed to answer everything in a deposition regardless of objections. Yep, you sure are.
As a defendant to a lawsuit in your individual capacity?
It
Right.
may have been if I get it right, it may have been in the BB matter.
So it's your testimony today. You've been added. You were a defendant in a lawsuit in one matter, and that was the BB matter. Is that
Object to
correct?
form.
I think they added me as an individual defendant, and they lost the case that went to jury trial. I think that's my recollection. I don't remember it very well. The man, BB, attacked me in a stairwell.
This is really funny because he says, I don't remember it very well. And then wait till you hear him describe this incident, which has like literally no relevance to anything.
And at my garage, and I think he named me individually in that suit, and then he lost that suit. That's my recollection.
Let me ask the question again, Mr. Abrams. Is this BB matter that you're referring to the only time you remember being added as a defendant in a lawsuit?
Object to form.
To my recollection, yes, that's my answer.
And you said the other party was named BB?
Yes,
Okay. What was the other party's full name?
Sean Beeson. We call him BB. I represented him in a matter
Yeah.
where him and his wife were both arrested for DUI. He was thrown in a drunk tank for being belligerent, and he sued the city. And then I put a restraining order on him for 9 months for attacking me in a stairwell. And then he sued, I can't remember if he sued me individually, but I think he did. And then he lost that suit outright at jury verdict. So we're going to move to strike that as irrelevant, object to form, and that it's going to lead to non-discoverable evidence. Under the rules of evidence.
Mr. Abrams, you are not allowed to.
Me.
I am allowed to.
He's-
interrupt you.
he's-
This is my
he's giving his
deposition
answer.
today,
You
sir.
can't, it's my
And
answer.
it
This
is
is my
not,
answer.
you are not allowed to put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put.
This is the funniest part. So remember how he was like pro se? He said, I'm representing myself pro se, but he has counsel there.
Objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you
Have you seen this? Also glad you're here.
have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions
There it is.
for
Move
harassment.
for sanctions for
Under
harassment.
Rule 30D. You
Excellent.
can look it up.
Move for sanctions for harassment. Love it. Love it.
Know it.
Beautiful.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you
Object to form.
for continuing to obstruct and not answer any of my questions.
Object to
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished.
Debatable.
If you laugh at me one more time, we're gonna walk out.
We're going to move for 30D3 section.
We're gonna move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published
Sanctions are flying fast and furious, guys.
on the internet about you and your rock band, and you're gonna be laughing at me.
Oh my God.
And you moved for sanctions and had them denied every single time in this matter, and the jury should see that too. Every single one has led to no sanction.
Mr. Abrams, are
Including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams,
Let's move on. Do you have a question for me? You sued my firm belligerently under the abuse of your law license where we countersued you. We have a counterclaim against you for abuse of process for misusing your law license. You sued me for fraud, civil conspiracy, not civil conspiracy, which is a criminal act. So you did that wrong. And aiding and abetting, which is a criminal act. So you did that wrong. Ask me questions about that or I'm leaving.
For those of you guys who haven't seen this yet, y'all are in for a treat. We're yet to get to some of the most unhingedness part of this.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions. I just want to let you know that right now
Object to form.
and put that on the record. Mr. Sullenberger, I'm sorry.
Stop laughing at
Yes,
my lawyer.
This is
Stop laughing at my lawyer
Bizarre.
and stop harassing us.
Listen,
You brought us down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only 2 times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
objective form.
Objective form and privilege. So I assert
So
privilege.
now there it is. In case you're wondering why would he be going pro se if he's got counsel there? Now you're hearing the answer to that one.
Need not answer.
Sorry.
What privilege are you asserting, sir?
Attorney-client privilege, and
There. Attorney-client privilege with himself.
we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. It's,
I need a law book.
and
Oh my
I move to strike, and I move for, I move to strike the question. I refuse to answer under privilege, and I move for
Sanctions?
a protective order on the question. So certify the question
He's gonna
and
say
move on.
I feel like we move here.
You've again not answered my questions. You've made a absolutely baseless assertion of privilege. Are you aware that in a deposition, the proper objections that your lawyer are allowed to make are as to form and as to foundation? If there is a matter that's privileged and your lawyer objects to it on the basis of privilege, he can instruct you not to answer. Otherwise, you need to answer all of the questions that I give to you today. Do you understand that, Mr. Abrams?
He's raising an objection to privilege.
There's a pending question. Could you please read it back?
What law are you referring to, Mr. Abrams?
I need a law book.
Go back. Aside from traffic tickets, have you ever been named in a criminal action?
So objection, privilege, move on.
You are not answering the question today. You're refusing
Objective
to
form,
answer it, Mr.
objective
Abrams.
privilege,
Move on.
move on.
It's the answer. Objection, privilege, move on.
What privilege are you asserting today, Mr. Sullenberg?
Attorney-client privilege, he's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
Sanctions?
I can't even get through my initial questions here
That's
because
your-
you are being so obstructionist
That's
today.
because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to form.
For misrepresentation. of the
Are you
evidence,
aware?
Mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just got asked
I
me.
did.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it.
And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being
What-
arrested.
What part of my question asked for any attorney-client privilege?
He's not being deposed.
I don't have to, I objected. I objected to form. I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
Clear that
today,
you're harassing
and
us.
you are refusing to answer
We've
any
answered
questions
every
today.
question, read every question.
Yeah, you have not.
We disagree.
Are you
Okay,
guys
let's
seeing
ask a couple more questions. Mr. Abrams, what are the pills that you just took?
There it is.
Object to
None
form.
of your business. None of
Privilege.
None of
What are
your
those?
business.
What are those other pills?
Object to form, object to privilege.
None of your business.
Medical privilege. Don't have
Mr. Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No,
Okay. Have you taken any alcohol before you came to this deposition today?
no,
Any medication whatsoever?
no.
No. Just these pills that you're taking here
Yes.
that you are refusing to answer what they are.
Yes.
Medical
None of your
privilege.
business.
Mhm. Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object-
I don't
Objective
recall
form.
that.
You don't recall that? Okay. Well, we have a couple of witnesses to that, including Mr. Sullenberger.
More pills.
In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Mr. Abrams, do you recall the motion to quash the subpoena for your testimony
Yes.
that you filed? And you attempted to quash the subpoena to disallow your deposition to be taken, correct?
Object to form.
I don't recall that. I remember we successfully quashed your bad faith depositions. You moved for attorney's fees and you were denied by the special master. That's my recollection, that he found them,
Special master.
that he found them. When we told you I would be out of town to, in bad faith, then schedule the deposition to pull me out of my vacation, he found that to be objectionable and he commended me on taking a vacation under the stresses of this profession. So I remember the special master commending me and quashing you. That's my recollection.
Are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you
Okay.
laughing at? Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
Your
testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the
evidence,
jury,
Lally.
put it in front of us, we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful
yes.
deposition or let me go.
is there anything else you'd like to say, Mr. Abrams?
Depends on what your next question is.
In the motion that you filed to quash the subpoena, isn't it true that you admitted to the special master that you were in fact in town?
Object to form.
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep. We found
So
your
you were in
conduct to be
town at the
offensive.
time, you were in town on the time that you were scheduled to be deposed, but you
Object to
nevertheless moved to
form.
Asked and
quash.
answered. Move on.
Mr. Abrams, are you refusing to answer?
I answered
Object
your
to
question.
form.
Move on.
You don't get to not answer when you object.
Object to form.
Do you
I
understand?
answered the question, and I even told you what time I returned on the day. What more? Why are you harassing me?
Mr. Abrams,
Stop harassing me.
listen to my questions. Today, that your job is to listen to my questions and answer your questions under oath. Do you understand?
He's been
Objection
shoveled.
to form.
He's been
Asked and
shoveled
answered.
pills many times.
Move on.
I'm waiting for your answer, Mr. Abrams.
Her first question was the same question you asked. If we need to go back to the very beginning to ask whether I said I would be here under oath, we can go back and ask the court reporter.
Mr. Abrams, in that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your
Object
filing?
to form
No.
medical privilege.
Privilege.
Medical privilege.
Yes. Move on.
You have
What privilege is that?
None of your
absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of the certain medication that you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection,
you've
privilege.
come into this deposition today with a handful of pills that you refuse to answer questions about
Yes,
what they are.
none of your business. HIPAA protection, privilege. Move on.
We are going to continue this deposition now, Mr. Abrams.
Okay.
You have made it clear you are not willing to answer any of the questions today. You have been objecting. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition. as well.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D, I think it's
30D3.
for harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm was surreptitiously brought into this lawsuit for fraud, conspiracy, and aiding. And he hasn't asked one question in furtherance thereof.
We will
Until he
continue
does,
all three of the
we will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
Oh my God, I love it so
We
much.
will continue the deposition and go off the record at this time.
We're going off the record at 9.
Beautiful. Well done. So in this short video, they had 5 I don't recalls, 30 objective forms, and 8 motions for sanctions. So there you go, guys. Okay, so now let's jump right on into Karen Reed. Hope you guys enjoyed that train wreck. Okay, I just have to unshare, reshare. Okay, so we're going to go in chronological order here. So the first filing being, let me zoom in. So some of you guys may have seen this before, but anywho, I know there were some requests that we do this. Hopefully Fender will be able to join us from India. Shout out Fender. Okay, so this is Defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. And I had heard rumblings, I guess it was yesterday, that they'd filed a motion to dismiss, and I think that was sort of something that was maybe circulating, you know, probably due to mainstream media labeling things wrong and whatever. But basically, I think a motion to dismiss is coming. And this was the first step being to recover the expert-related expenses. But this is so egregious that I don't see any way around it. And it's interesting here because, right, we are only 2 months before trial. Oh my God, Blackwater, yes. He pops pills like Alec Murdoch's imagination. Dude, yes. Thank you for that. Amazing. Oh my God, yes. So because, yeah, this is just so egregious. Okay. And we're going to learn a lot of new information as well here. So, all right. Hopefully you guys can, if you're wanting to follow along visually, you can, let me zoom in a little bit more here. Follow the little hand. Okay. So Defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. Now comes now the Defendant Karen Reed and respectfully, blah, 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 blah. Okay. Associated with defense expert Matthew Erickson's December 2024 trip to Massachusetts, be paid for by the Commonwealth. Those costs, which include travel expenses, lodging, and other accommodations, and expert fees associated with the trip to the Canton Police Department, were incurred after the Commonwealth agreed to allow Mr. Erickson to visit the Canton Police Department so that he could perform an independent analysis of the CPD DVR system and any footage. So we're talking about the Lallyport here, guys. It contained from January 29th, 2022, between 12 a.m. and 11:59 p.m. When Mr. Erickson arrived at the Canton Police Department, all original DVR footage from the relevant date had been destroyed and, at best, due to improper preservation by the Commonwealth. At best, improper preservation, right? If not something more nefarious. Because the Commonwealth failed to preserve the original video evidence, Mr. Erickson's trip to Massachusetts was futile. The costs associated with his travel to the Canton Police Department would not have been incurred, but for the Commonwealth, I love a good but for. The Commonwealth's representations that the evidence existed and that Mr. Erickson would be able to obtain an original copy of the video surveillance footage at issue. Accordingly, in the interest of justice, this court should order that the Commonwealth, not Miss Reed, pay the cost of having her expert travel out of state to obtain a copy of the video surveillance footage, which the Canton Police Department, an agent of the Commonwealth, failed to adequately preserve. So we don't need to read the beginning part here of this factual background, but let's read this part. So in preparation for trial, the defense requested, oh, shout out to Heather. Glad you're here, my friend. Representing Glenn as well. Requested access to the Canton Police Department DVR system and drives that hold recordings from the CPD security camera system so that defense expert Mr. Erickson could obtain video files in their native file format with all available metadata from January 29th, 2022, between 12 a.m. and 11:59 p.m. In order to ensure the accuracy and a complete download of all available data and metadata, the defense requested that their expert be allowed to make a mirror image of the DVR's system drive. And let's just not get that confused, because we know that the Lallyport video was a mirror image. That's not what they're mentioning here. They're meaning like an exact copy of it, basically. So, or well, actually, I don't know. Maybe they mean, yeah, I think they mean they want exactly the way it is, because it's just funny that they use the word mirror image. That's not usually the language that you see here. Shout out to Twizzlestick as well. Twiz. It's funny because I only today realized the one Z, and now I'm like, it could be Twizzle. But anyway, I've always been thinking it was two Z's in my brain. So anywho, right, the original. I mean, that's what makes sense. It's just, again, I mean, maybe this is supposed to be, maybe the mirror image thing, maybe that is supposed to be like a little jab, right? Because it is interesting that they chose to use that languaging. Right. Thank you, DB. Yes. By the way, DB, would you like a custom command? So yes, again, do you guys see why it's funny though, that they said that? Like, it's just funny. Okay. This video footage is of critical importance to the defense. The Commonwealth has provided the defense with CPD footage on 3 occasions. And let's take a look at these footnotes. So footnote 1, a motion to dismiss for extraordinary governmental misconduct. I mean, it's been a long time coming, right, guys? Based on the destruction of this and other exculpatory evidence is forthcoming. There we go. That's really funny because, you know, I had, you know, of course I'd heard people cover it. I hadn't read through this until now. And so I didn't actually know this footnote was here. And that's why at the very beginning, I was like, yeah, there's going to be a subsequent motion to dismiss. But I didn't know that this was actually cited here. That's funny. This motion should not be deemed a waiver of any such claims or issues. Notably, when Mr. Erickson arrived at the CPD to extract the video from the DVR system, the security camera system was set to overwrite older video surveillance footage with new video surveillance footage after approximately 30 days. Notably, however, each of the 3 instances in which the Commonwealth produced CPD footage to the defense was far outside the 30-day cliffhanger. 30-day. Wait, what? Oh, because it's a footnote. 30-day window. Okay, so it continues down here. 30-day window after which the CPD DVR system was set to overwrite older video recordings. Thus, an agent of the Commonwealth must have saved all of the aforementioned footage in playable format at some point before the end of the 30-day period, which ended in February 2022. The Commonwealth therefore had care, custody, or control of all the footage produced to date during the discovery phase of the initial trial and chose not to turn it over to the defense in a timely manner. So DB, let me know. It'll be !DB, and then it can say whatever you want it to say. That's hilarious. That's also funny. CBD footage, right? There's a lot. Yeah, CPD and CBD and DVR, lots of letters. So okay. So then it said on April 4th was on the previous page. Before the first trial in this matter, the Commonwealth produced footage from the CPD main driveway and CPD Lallyport front wall for the very first time. The Lallyport front wall footage was, by the way, shout out to DSN for coming up with that brilliant, what would you call it? name for the Lallyport there. So ever since then, it has now been known on this channel as the Lallyport. Footage provided by the Commonwealth omitted a 42-minute interval during which the SUV arrived at the CPD Lallyport garage. This missing footage could have been used to show the condition of the SUV's right taillight, upon arrival at the Lallyport, and to date would be the only footage that serves this purpose. The condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. Yep, facts. Facts, 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 facts. Yeah, think about it. Let me know. Let me know. I know, right? For sure. It just magically overwrit the exact time they need. Yes, indeedly do. Mid-trial, you gotta love that, right? On April 23rd, 2024, via a link. You know what's funny is that they're going to be in trial, like, they're going to have their trials overlap, right? Because if they start April Fool's Day, which is what they're supposed to, and then, you know, assuming it goes for what, 4 weeks or something? Anyway, it's just funny because it's like going to be in the same, roughly the same window, but just a year later. Via a link share link entitled Additional Lallyport Video Download Link, the Commonwealth produced additional footage from the CPD Lallyport back wall. At trial, Trooper Yuri Buchanan testified on direct examination that the footage of Miss Reed's vehicle from this interior Lallyport camera was an accurate depiction. Oh, guys, hold on. There's something I have to do here. Give me just a moment. And I'm going to read that part again. Okay. At trial, Trooper Yuri Buchanan testified on direct examination that the footage of Miss Reed's vehicle from this interior Lallyport camera was an accurate depiction. Oh my God, I forgot to replace my goat battery. Oh my God, he's dying. Can you guys hear that? That is so sad. I think I have the battery I need on hand. I'll take a look for it when we get to the hearing. That's the goat. The goat, it was only a matter of time, right? That the goat was like, I'm worn out. The goat has laryngitis like I had at the beginning of January. Okay. The poor goat. Could you guys even hear that? That's really depressing, right? Oh my God. Poor goat. The goat is on his last leg. Oh my God. Oh my God. Okay. That it was an accurate depiction of the Lallyport and the SUV, and that as seen in the video, no law enforcement officer approached the right rear taillight in italics. On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, despite neither the Commonwealth nor Trooper Buchanan having mentioned it on direct examination. Shocker, not. Okay. A little zoom action. I can just do it with scroll. That's easy. There we go. Learning. Therefore, shout out to Kane. Happy to see you again, my friend. So you could hear. Okay, good. You could hear the squawk. There's going to be lots of squawking. You know, and then there's the poor goat on his last, like, I'm gonna have to find that battery. You know, there was whatever the last live stream was where I was using the goat and I was like, oh my God, I feel like the goat's losing his voice. And I like said, let me look and see what battery it takes. Well, so here's what happened. I did like a Google search for what battery it takes and I found the battery. And then when I went to Amazon to buy it, it was like purchase again. And it's like a set of 12 and it's like a really specific battery. So that's why I'm like, that means I must have them here for something. So they're somewhere. Anyway. Okay. So therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, that person was in fact standing near the right rear taillight, i.e. the taillight at issue. It remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial CPD surveillance footage was turned over by the Commonwealth. And you know, you guys, do you remember at the time being like, why is this trial still happening? Like they just moved right on and it was like, what? You know, I mean, they probably could have like been like, hey, what the fuck are we doing? Like, let's all go home at that point. I feel like though they were so sideswept that was a pun. That was an accidental pun. That was a trooper Paulism, not even intentional. Wow. They were so sideswept like Trooper Paul. They were so sideswept by this that I think they just didn't even know how to handle it because it was so incredible that this even happened. Oh my God. Okay. Most recently, post-trial on October 10th, 2024, the Commonwealth again provided new video surveillance footage. So this was news to us during this filing, right? We didn't know this. This time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side angles. Now, I remember, I can picture this from the day at trial when we were covering this. And I remember this very well when all this was, they were bringing in all the, the different, they were talking about the different cameras. And I literally remember, and I think we even did like a field trip to the CPD. And I think we even looked for the cameras, which is funny because we did that last night for, with BK with the, in other words, it wasn't the first time we've gone hunting looking for surveillance cameras, right? But anyway, I literally remember being like, where's all the other camera footage, right? Like, there's cameras everywhere. Anyway, I just remember being like, what the fuck is going on? Where is it? So anyway, now we've got some of it. It looks like was turned over after the first trial, which again blows my mind. This footage shows Brian Higgins arrive in the parking lot, and they should have added here fucking wasted. But anyway, parking lot of the Canton Police Department at 1:26 a.m. Enter the Canton Police Department and speak to some unidentified individual or individuals plural on the phone as he is leaving the Canton Police Department between 1:34 and 1:34:52 and 1:34:56 a.m. Significantly, this material and relevant evidence which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton Police Department shortly after O'Keefe's death was withheld from the defense at the first trial, which is just, again, absolutely fucking insane. Let's see what you guys are saying. What's happening with Kitsmits? Shortening something up? Yeah. For sure. Yeah, that whole thing. I mean, there was so much. And it was like one thing after another, right? It's like, all this shit with Brian Higgins, that happened before we got into the Trooper Proctor nonsense. And then that was the thing. And then it got into the Trooper Paul nonsense. And it's like, this was sort of like, and this feels like this was from a trial 10 years ago, right? When this whole thing with Brian Higgins, incredible. Okay. So this video surveillance footage at issue was a major point of contention at trial, in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced to the defense from the CPD. The footage produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability, including the presence of the inverted video and the large-scale gap missing from the feed at the precise time at which Miss Reed's Lexus should have been shown entering the CPD Lallyport garage, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. The fact that the Canton Police Department produced video surveillance with an inverted video and a gap in the footage at the critical moment, i.e. at the precise time Miss Reed's SUV arrived at the CPD garage, is not trivial. It goes to the heart of Miss Reed's defense. Yes. Oh, that's terrible. There's still, I remember Black Widow was letting us know in the Discord that there was a lot of power out there. I don't think I knew about the storm though. But yes, Ireland is its own separate, it's its own Republic of Ireland. Shout out to the Republic of Ireland. Black Widow, by the way, has the most beautiful accent you guys have ever heard in your lives. So, okay. In response to the defense's request, Special Assistant District Attorney Hank Brennan agreed to allow defense access to this critical information and to make the arrangements necessary for Mr. Erickson to extract video from the DVR system. Accordingly, Mr. Erickson traveled from Phoenix, Arizona to Boston, Massachusetts on December 11th, 2024. And after making the arranged visit to the Canton Police Department, returned to Phoenix on December 12th, 2024. So a very short jaunt. The work Mr. Erickson did in connection with this trip, as well as the flights, hotel stay, Uber rides, and other accommodations, blah, blah, totaled $12,229, which honestly is not that bad, right? Like, they're not over exaggerating that amount, even though they probably could have asked for, there's no for your trouble, right? Here's an extra, amount for your trouble type of thing here. Hi, Top Cat. Happy to see you again, my friend. Oh, it did. But the problem was it was inverted. It was backwards. It was like a mirror image. Well, there were many problems. That was just one. There were also people they're like apparitions. You can't remember that. people like appearing and disappearing and then like gaps in time missing. It was, yeah, special. Okay. As planned, Mr. Erickson visited the CPD on the morning of December 12th, 2024 to extract video from the DVR system. He arrived around 9 a.m. and was met by Colleen Crawford, a multimedia director and certified forensic video technician from the Norfolk District Attorney's Office, as well as 3 others. Miss Crawford expressed surprise, like a, hold on, a surprise? You mean like a poop surprise? Surprise! Okay. Okay, and expressed surprise that Mr. Erickson was there to extract the video from the DVR and relatedly skepticism that the footage would still exist. Mr. Erickson subsequently asked whether anyone had accessed the system to determine whether the relevant video footage was even present. They answered no. Well, of course they didn't. Notably, before Mr. Erickson made this trip to Massachusetts, counsel for the defense team spoke directly with Miss Crawford, who was made aware of the footage the parties had agreed would be extracted by the defense. After photographing the relevant equipment, Mr. Erickson began recording and then accessed the system. Initially, it appeared to him that there were only 30 days of video history and consequently that the relevant footage had not been preserved. That impression was confirmed. When he navigated to the appropriate section of the DVR system where a search by day and time could be performed and ran a search for the time in question here, that returned 0 search results. Based on the size of the drives, the percent usage, and the remaining usable drive space, Mr. Erickson concluded that there was mathematically no possible way for the videos from January 29th to be present in December of 2024 when he performed this search unless they were manually saved and or properly preserved via standard forensic protocols. Good night, Kane. Have a good sleep. See you soon. Yes, ghosts, for sure. Yeah, it's really funny. There's a number of people who in the scroll crew who tend to, whether it's some intentional or not, Blackwater being one of them, fall asleep and or sometimes wake up to a live stream. So love it. We'll be here for you guys when you wake up most of the time, probably. Okay, so next, Mr. Erickson began the process of generating any activity logs for the date of interest. This request ran for an abnormal amount of time without showing results. Interesting. I have questions about that. What does it mean? Oops. What does it mean by abnormal amount of time? Like, okay. When asked whether the system had ever behaved, oh, well, there you go. Keep reading. Had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged. Why does that not surprise me? And said he didn't know. Of course. I would goat, but my goat is half dead, or well, almost dead. After investing approximately 10 minutes into this, and actually I have a command though. Let's do that in lieu of, well, before I can replace that battery. We'll do that. Where's my goat? Okay. Okay, so he shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, Mr. Erickson determined that the relevant activity logs were also gone. Mr. Erickson asked the individuals whether they had done a forensic extraction of the drives to get the original data, to which they answered no. He asked how they preserved video when they needed to, and they responded that they simply manually saved the video from the DVR. Finally, he asked if they had a written protocol in January 2022 or now for saving video. They responded they did not. The individuals refused to provide Mr. Erickson with a copy of the original files that they pulled from the DVR system, stating that it had already been provided to defense counsel. When asked how they produced the footage to the court and or the defense, they looked confused. Wow. Mr. Erickson clarified by asking whether it was provided on a USB drive, a disk, or a share link. They could not tell him for sure, but eventually said it was probably a share link. Wow. I'm not dead yet. I'm getting better. I feel happy. Monty Python references. So, right. I mean, the thing is, though, is that a preservation order in this case is not, well, I can't say what Judge Bev will do because Judge Bev. But in any normal situation, for the most part, right, it wouldn't be necessary because this is, well, there's a number of issues here. So one, it's part of what they do. They're bringing that vehicle in, right, to build this case. And this is evidence, right? It's just like how, you use body cam, you're documenting and for chain of custody purposes. But beyond any of that, the other thing is this: the fact that they have some of the footage is the big problem here, because it shows that they have that. And why do they have that? Like, in other words, if it just gets overwritten and they like, that's the big linchpin in this entire thing, that it'd be one thing if they just didn't have any of it, right? But they had some of it, and what they have is messed up, and they didn't turn it over until halfway or towards the end of trial, right? And then on October 10th, 2024, magically they find more footage. How? If it so it just doesn't add up. Okay. The way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most, store videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then data is converted by the system to a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash to verify the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Due to the Commonwealth's failure to preserve the original surveillance footage, Mr. Erickson was unable to extract video from the DVR system footage to obtain relevant footage in those hours there, as previously arranged and agreed upon by all parties. Thus, the Commonwealth's failure to adequately preserve evidence, I mean, there it is right there. They have to preserve evidence, right? Has resulted in the destruction of 1, a forensically sound image or hash verified copies of the video surveillance footage, and 2, logs establishing the individuals who accessed, manipulated. So here we have, again, there's a number of issues. We've got potentially exculpatory evidence, right? I mean, and you've got, it looks like there's been tampering. And I'm not even talking about fuckery with the taillight. I'm talking about tampering with the video itself. And you've got chain of custody issues, right? Okay, so or deleting the footage from January 29, 2022 from the CPD DVR system. Mr. Erickson left only with the audio and video recording of his work and photographs that captured from the DVR menus that he captured, right, which demonstrate that the Canton Police Department and Norfolk County District Attorney's Office failed to preserve all video surveillance footage and associated logs, both of which are material and relevant to this case. Hi, welcome. I think you might be new. I don't recall your name. So welcome. Happy to see you. We love having new friends as a part of the Squirrel Crew. Awesome stuff here going on. We're just getting into these documents, and then we will dive into the hearing. And also, I'm super excited because they get into phone extractions in the hearing. Okay, argument. Love argument. Okay, the Commonwealth had an obligation to preserve, as I was just saying, the original DVR surveillance footage from January 2022. So again, they have an obligation whether there's a protection order in place or not. This just goes without saying. In Massachusetts, quote, the Commonwealth has a duty to preserve exculpatory evidence for the defendant to inspect, examine, or perform tests on. State courts have repeatedly stressed the need for prosecutors to do their utmost to preserve and present exculpatory evidence which is available to the prosecution. Evidence is considered exculpatory if it merely tends to diminish a defendant's culpability. Any evidence which tends to impeach the credibility of a key prosecution witness, such as evidence showing that the footage of the defendant's vehicle, the alleged murder weapon, has been tampered with or altered, is clearly exculpatory. I would add also in terms of impeachment, right? Impeaching Yuri Buchanan by saying when he says, yeah, this is normal, nothing's wrong here, this is accurate, a depiction of what was going on. And, he said that, like impeaching him too, right? Anyway, okay. And then 2, for the loss of the original DVR surveillance footage, Ms. Reed is entitled at minimum to recovery of expert-related expenses. When potentially exculpatory evidence is lost or destroyed, as here, a balancing test is employed to determine the appropriateness and extent of all remedial action. The courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Okay. Here, the balancing test indicates that the Commonwealth is culpable for the loss of the original footage. The footage was material evidence, and its loss prejudiced Ms. Reed. So a lot of this, again, this is going beyond just recovering the expenses. But again, there's going to be a subsequent filing, as I speculated, and then we saw the footnote, right? With a motion to dismiss and with outrageous prosecutorial misconduct, which again has been a long time coming. So excited for that. But they're laying a lot of that groundwork with this filing here as well. So the Commonwealth is culpable for the loss of the original DVR footage. Critically, for purposes of this balancing test, the Commonwealth is culpable for the conduct of its agents, and culpable conduct includes actions ranging from intentional to negligent and inadvertent. And these are questions that we've been asking in this case as well as other cases, right? Was this just stupidity, basically? Was this just being dumb? Was this just, incompetence, right? Was it negligence, or was it willful misconduct? There's been a lot of cases recently, right, where that's kind of sadly what we are having to ask ourselves. So I'm guessing Kim, is that typically unique? Welcome, Kim. We have a name. Wonderful. And they're making a record of all this. Yes, yes. By the way, DB, if you're still here, or he might be still pondering his command, but let me know if you thought of your command, if you thought of one. Okay, so, right. Therefore, the failure of Canton Police Department to preserve the footage, whether intentional, reckless, negligent, or inadvertent, is attributable to the Commonwealth. And here they're citing the prosecutor's obligations for proper handling of exculpatory evidence extend to material in the possession or control of members of the prosecutor's staff and any others who have participated in the investigation or evaluation of the case, and who either regularly report or with reference to the particular case are reported to this office. So remember, so this means that it's the prosecuting office, right? But also, like, it would extend to any law enforcement or agencies, right? They are considered as part of the office as an entity. We've seen that in other cases as well. Here, the Canton Police Department was in possession of the footage, knew that it was potentially exculpatory before it was lost, and failed to preserve it. And there's going to be a footnote there. So let's see here. The relevant footage was from January 29, 2022. Miss Reed was arrested just 3 days later by Sister and District Attorney Adam Lally. Let's take a look. We've got our Lallybird here. For anyone who hasn't seen this before, for anyone who's new, if you're joining the Discord, we do have custom emojis, and one of the custom emojis is this Lallybird. And the reason it's a Lallybird is because when we were covering the trial the first time around, we were sick of hearing him talking. And at some point, I think I was mimicking him. I was like, I'm Lally, what if any? And it was like a squawking voice, right? To be funny. And then we started getting into joking about like his hybrid spirit animal, because all of these people have one. Like, we've got a lot of these. And we just, so then I think somebody made the joke of like Iago from Aladdin, So then I was like, oh, well, now I've got to make this. So at first I made it with just like the head. And then I was like, wait a second. So he's got his lucky tie, his closing argument tie that he wore on Closing Arguments, which is the tie, literally the same tie on him. And that was not the easiest thing to do. I literally had to get the tie and crop it and all that. And so he's wearing his actual Closing Argument tie. So yes. Yep. Definitely. Yep, definitely. Yeah, Kit's been saying, according to this, it doesn't even matter what intent, if any, is behind all the what, if any, intent. That footage was CPD's responsibility. Any intent in losing it, ruining it is secondary. Yep, definitely. So DB was listening. Okay, I'm still sitting here, fingers tented, pondering what my command shall be. It must be perfect. Okay, take your time for sure on that. Take a few days. Just let me know. And if you think of it and it's not during the live stream, you can always just message me on Discord. Okay. Brilliant. So the Commonwealth was thus on notice about the potential use of the footage. There it is, with ample time to properly preserve it, even if footage was normally set to lead after the release. I mean, that right there, that sums it up. This footnote really does sum it up, as Kitsmans was saying, right? That because of the timing of the footage on January 29th, and then the arraignment 3 days later, or the arrest 3 days later, rather, and then the arraignment the next day, right? They were on notice to preserve it. Okay, so then we just would have read that footnote, and failed to preserve it. Relevant members of the Norfolk County District Attorney's Office also failed to take steps to have the data preserved. Okay, the original DVR footage was material. Evidence is material if, considering the entire record, it creates a reasonable doubt as to the defendant's guilt that would otherwise not exist. Again, citing Harwood. Here, the relevant video evidence speaks to the state of Miss Reed's vehicle immediately after John O'Keefe's death, as well as the handling of that vehicle by CPD, both of which are key issues in this case. In some cases, it is important for the Commonwealth to maintain and preserve the original piece of evidence rather than a copy. Yeah, I would say so. And here, finding that the loss of original paper bag with handwriting found at a homicide scene did not prejudice defendant because handwriting expert stated that the photograph of the bag was adequate for his analysis and testimony was based on the photograph which defendant had access to. So they're saying here that it prejudiced the defendant. This is one such test for, this is one such case. First, the original DVR data and footage was necessary for proper analysis of the authenticity and integrity of the video, both of which are actually at issue here. This is especially concerning in this case where there is substantial evidence suggesting that the videos have in fact been altered, despite claims to the contrary by the Commonwealth and its agents. And another footnote. Love it when we've got all these excellent footnotes. So specifically, the surveillance footage produced by CPD included an inverted video with footage, or sorry, in footage with significant gaps. Are they going to say ghosts? Please say ghosts. Including gaps at the precise time Miss Reed's Lexus entered the CPD Lallyport garage. Second, because of the methods used by CPD to access a playable format of the surveillance footage, the videos ultimately produced by the Commonwealth are of lesser quality than the original footage. For these reasons, the fact that the videos are available in some form is not sufficient. These videos in their original format were material and should have been preserved. And then the loss of the original DVR footage prejudices Miss Reed. As detailed above, there is significant evidence that the DVR footage provided to defense and shown at trial was altered. The fact that original DVR footage is now permanently unavailable hinders Miss Reed's ability to demonstrate the differences between the original footage and footage provided to the defense and shown at trial. Differences suggesting the footage was tampered with or otherwise altered, and deprives her of critical evidence about how those differences came to be. Ultimately, the loss of this evidence in its original format, which resulted directly from the actions and inactions of the Commonwealth and its agents, hinders Miss Reed's ability to put on an adequate defense. The loss of the DVR footage in combination with the Commonwealth's misrepresentations further prejudices Miss Reed by burdening her with a significant and unnecessary financial expense. The Commonwealth, by agreeing to and arranging the CPD visit, led Miss Reed and her team to believe that the relevant footage existed and that the defense's forensic expert would be able to forensically extract the relevant footage if he flew to Massachusetts to visit CPD. Because of the Commonwealth's misrepresentations, defense expert Mr. Erickson did fly from Arizona to Massachusetts, stayed overnight in a hotel, and traveled from CPD for the agreed upon imaging. Yet he was never able to perform the imaging as the Commonwealth had failed to preserve the information. The Commonwealth failed to take any steps to determine whether the footage still existed before prompting the defense to send its expert to Massachusetts, despite an apparent understanding by CPD technicians that such footage did not exist. For the services rendered on December 12th and the associated costs, they're requesting that the expenses, which we have already talked about here, the expense is significant and draws on the financial resources needed by Miss Reed to defend herself at trial in this matter. All right, the appropriate remedy for the loss of this evidence is at minimum recovery of these expert-related expenses from the Commonwealth. Given the materiality of the lost evidence, the prejudice to Miss Reed, and the culpability of the Commonwealth, Miss Reed is entitled to a remedy. There is no particular remedy for the loss of evidence. Instead, our courts have fashioned or upheld various judicial remedies from allowing the defendant to bring to the jury's attention. So this would be like a like it's considered a sanction, right? But it'd be a special jury instruction to say, hey, like this was tampered with, essentially, right? So yeah, bringing to the jury's attention the Commonwealth's negligent handling of the evidence to the dismissal of the indictment. Bam. These decisions are with the sound discretion of the trial judge, unfortunately here, and are reviewed for abuse of discretion. So in other words, the judge gets to make a decision, right? But then that decision is going to be reviewed for their abuse of the discretion that they have. Okay. Because the travel expenses and expert fees associated with this trip were the direct result of the Commonwealth's representations to the defense, and because the Commonwealth's failure to fulfill its obligations of preserving the video made to the defense's expert trip to Massachusetts futile, it made the defense expert's trip to Massachusetts futile, Miss Reed is entitled at minimum to recover these costs. Allowing Miss Reed to recover these expert-related expenses from the Commonwealth is in the interests of justice. Great question here. I want to know who inverted it, right? I know. You know, I had a feeling when we were watching this trial as it was happening live, and it got to the part in the testimony with Brian Higgins where he arrives at the Lallyport, and it was like, I remember it was before we knew anything about any fuckery or like, well, okay, it was before we knew that anything was missing or that whatever, right? It was like, we were learning things as they were coming out. And I remember when it got to the part where Brian Higgins was like saying that he taught, and he was on direct, right? And he was like, I spoke with so-and-so, right? And it was like, he immediately started to try to throw, it was the person who was there in charge of the camera footage at the time. And he immediately tried to like throw that guy under the bus. Do you guys remember that? Where he was like, instead of just answering the question and giving a name, he was like, he gave the name, and then he was like, who was, brand new on the job and had just got, he was just started there or whatever. Like, and we didn't know what was coming at that point. And I literally paused and I was like, oh my God, don't tell me. At that point, I was like, don't tell me things are missing. Don't tell me things are missing. Like, I knew at that point I could see where this was headed. And anyway, so I had a gut feeling at that point that something happened there. But yeah, and the weird gaps, right? If it's motion detection, fine. Right. And I mean, there were plenty of people moving, I think, that entire time, because there were lots of people in that room, in the Lallyport, you know what I mean? So like if one person was standing still, there were other people moving around. But yeah, and they definitely did not say that, right? So if it was motion detected because of that. So, okay. All right. So Miss Reed is not indigent and therefore would typically be responsible for her own expert costs and fees. However, the Commonwealth's actions have caused significant unnecessary travel expenses for the defense expert, Mr. Erickson, and thus for Miss Reed. Accordingly, Miss Reed now seeks to recover these travel costs from the Commonwealth. To order the Commonwealth to pay these fees is within the court's discretion and is in the interest of justice. The interests of justice require the Commonwealth to bear the cost of having Miss Reed's expert travel out of state to the CPD to copy files which the Commonwealth knew had already been deleted. To force Miss Reed to pay the expenses out of pocket when she was already prejudiced by the loss herself, right, of course, would be a complete miscarriage of justice. Defense expert Mr. Erickson traveled to Massachusetts, right? A lot of this is kind of repeating here. Via its agents who were responsible for properly preserving the preserving the footage, but did not, and via Assistant District Attorney Adam Lally and Special Assistant District Attorney Brennan, who did not take the actions necessary to ensure the evidence was preserved by those agents, that the footage was not properly preserved and thus was non-existent. The Commonwealth induced the defense expert to fly to Massachusetts anyway, wasting Mr. Erickson's and the defense's time and causing the defense great expense. Miss Reed should not be forced to shoulder this unnecessary financial burden. The travel expenses and other costs associated with Mr. Erickson's December 2024 trip to Massachusetts were incurred as a direct result of the Commonwealth's failure to meet its obligation of properly preserving material evidence. This misrepresentation came at significant expense to Miss Reed. There's the costs again, because the Commonwealth arranged for the defense expert to travel to Massachusetts to inspect the evidence that the Commonwealth had not properly preserved. It is in the interest of justice that Miss Reed be allowed to cover the related costs. There's a lot of big bad wolves in this trial. Actually, I would say Proctor, I don't know what you guys think. Like, I mean, Trooper Proctor's probably going to have to win the prize, but there's a lot of them. Okay, so now we are going to go on to the next document here. And this is where it gets real spicy. You guys might have been a little bit familiar. Let me, I just have to unshare, reshare to get to this window here. Love it when they get into these, the language here and they get creative, right? Love it. So, and I will say, I do declare, that the only way I was able to find this, by the way, was like this. It has this thing on it. I don't know. This was what I was able to find for PDF. So anyway, it's just there, one on each page. It's not like, it doesn't ruin it. You can still read it. It's just like whatever you call it, thing from whoever uploaded this, wherever this was from. So anyway, okay, but we have it, and that's the important thing. You guys know how difficult it is to get these documents from Massachusetts. So, okay, next up, defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. So now we're going to get into the, I'm sure you guys are familiar, but just in case anyone's not quite so familiar, who's Richard Green? So this was one of the defense's expert witnesses from the first trial, and he was a cell phone expert. And so he already testified in the first trial. They had no issues with that. There was no Daubert hearing, no objections. I'm sure that'll be mentioned in here as well. But now they are, the Commonwealth has objected. And then this is the defendant's opposition to that. Well, okay, the Commonwealth made a motion to exclude him, right? And now this is the defendant's opposition to that motion to exclude certain testimony of defense witness Richard Green. Comes now, I'm going to switch it around because I like comes now better. Shout out to Runkle. The defendant misread and respectfully requests that this honorable court deny the Commonwealth's motion as to the expert testimony of Richard Green. As to one, his expert opinion that a Google search for Hoss Long to die in Kickdy or Hoss Long to die in cold was made on Jennifer McCabe's phone prior to 6:23 a.m. on January 29, 2022. And two, his expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches, and deny the Commonwealth's included request for an evidentiary hearing under the standards set forth in Daubert. And the relevance here, just by the way, too, is that this document right here, this is the reason for the hearing that happened today, right? The hearing, this filing, right, was prior, well, let me see, when was this filed? This was filed on January, 28th. So just a couple days before. So, and then the hearing today was for oral argument, right? On whether or not there should be a Daubert hearing on this expert. Okay. So, yeah, and deny the Commonwealth's included request for an evidentiary hearing. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert-Lanigan. And of course, in Massachusetts, they oftentimes will refer to it as Lanigan, but they're synonymous. Daubert-Lanigan synonymous. So, instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green, matters that courts resoundingly state are subjects for cross-examination and the jury. Yes, not the narrow function of the Daubert-Lanigan judicial gatekeeper. Now, you might be thinking, oh, wow, why does this sound familiar? Well, this is a lot like what we saw with Dr. Russell, where when they did have that Daubert hearing for Dr. Russell, and there was that lengthy cross-examination, a lot of us, myself and others, right, were like, this is not normal. This is like a practice cross-examination. This is not just merely, trying to satisfy, the function of this particular Daubert-Lanigan hearing. And we're seeing the same argument here from the defense as far as this witness that, again, that these issues, the conclusions and opinions, right, that is not the purpose of Daubert, right? That's for the jury. That's for cross-examination. The purposes of Daubert are just, is he qualified as an expert? And is this particular topic, has that been found to be, has that been found by the courts in the particular jurisdiction to be a, what's the right word for that? Like approved as a topic which you can testify about, right? Because there's new fields that come out, right? Like new technologies and new areas of science and new areas of expertise. And, you guys saw that with the dog bite thing, right? Like, is this legitimate? Are there standards that it can be peer reviewed, and can it be, is there the proper methodology? We heard that a lot with Dr. Russell. So, okay. So, right. Moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. Right. Is the methodology reliable? Right. As a result, in addition to the denial of the motion, no evidentiary hearing is justifiable. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach to the Commonwealth, of the Commonwealth, to deny Miss Reed the ability to present her defense through her well-credentialed methodologically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. I had never heard this before. Gatling gun. Never heard that before. but we're getting spicy. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search Hoss Long to die in the cold existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp at or before 2:27:40 a.m. and in a deleted state. And there's the search artifact without any objection from the Commonwealth as to his qualifications or methodology. And for good reason. Mr. Green has been accepted in several United States courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts for the Commonwealth employed. So again, this is where it gets interesting, and we're going to hear this as well in the trial, or the hearing rather, right? That this is the battle of the experts. This is what makes for really interesting and exciting and informative trial watching. And this is also why they have the trial, right? Because in other words, when you've got experts that are equally credible, which my read, let me know what you guys thought, right? But in terms of the first trial, the Commonwealth's experts, Mr. Whiffen and Miss, oh my God, what was her name? I'm sure it's in here somewhere. Miss Hyde. Yep. Mr. Whiffen and Miss Hyde, they seemed credible, right? They seemed to know what they were doing. I didn't find them to be a shit show like a lot of the other witnesses, so and same with Richard. I keep wanting to call him Kevin. Richard Green. Same with him. So you've got witnesses that are like, let's say they're equally as qualified, right? And that they also use the same methodology, right? And yet they can come to different conclusions. And that's why you need the jury. So, okay. Anyway, so just pointing that out, right? Because it's the same methodology. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone, verified the hash signature value of the image file, took the image file and saved it to their computers, servers, hard drive, etc., and then processed and evaluated the image file with the appropriate tools, such as Cellbrite Analyzer and Magnetic Forensics Axiom. Was there another Kevin? Trying to think. That's funny. Yeah, I don't know. For some reason, like, I'm not even joking. Like, every time I was searching for these documents, I'm not even kidding about the Kevin thing. I kept searching for Kevin Green and not finding it. And then I was like, oh my God, why do I keep calling him Kevin? His name is Richard. So that's it. This is literally, my brain has been doing that. I don't know why. Okay. So while Commonwealth witness Ian Whiffen used only the Cellbrite Physical Analyzer and Artex tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using 4 of the same tools. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Cellbrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous reports that it is best to use multiple tools. That is very interesting. Importantly, it was disputed by all expert witnesses at the first trial that the 2:27:40 a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analyses using Cellbrite Physical Analyzer forensic technology available and on the market at the time. So just to reiterate, the significance of using more than one program, right, methodology, is because, for example, here with Cellbrite, with the version on the market at the time, every witness, they all said that when you use Cellbrite, right, that search artifact was present. And where it got into the nitty gritty was when they used additional, programs, and then they saw different things. So it is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as, and then more comprehensive than, that of the digital forensics witnesses of the Commonwealth. It is the opinions and conclusions, not the methodology, of the witnesses that differ. Let me read that again. This is exactly why we have trial. It is the opinions and conclusions, not the methodology, of the witnesses that differ. So again, same credibility, same training, experience, whatever, again, they were all well qualified in my opinion. That was not at issue. And on top of that, the same methodology, and arrived at different opinions and conclusions. But that difference is not a Daubert-Lanigan issue. No, it's not. That is an issue for the trial and for the jury. What has changed since the first trial? The answer is disturbingly Orwellian. Love it. Yes. And brings the prosecution closer to, if not squarely within, the danger zone of legal Tyranny. Tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement-centric digital forensics consultant, appears to have gone back to his company, Cellebrite, to have its researchers perform further updates to its physical analyzer programs, such that the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Cellebrite programs. Y'all, danger zone, I know, right? He uses Orwellian again. The 2:27:40 a.m. search artifact has now nefariously become, without explanation, the Orwellian unperson. Oh, goodness. After Cellebrite completely rid itself of the 2:27:40 a.m. search artifact that is incredibly inconvenient to the theory of the case of the Commonwealth now comes now before the court saying the unilateral and unexplained Cellebrite updates to remove the 2:27:40 a.m. search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is more accurate. I'm going to read that again. So this search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is most accurate. Yep. So, and we see this again, just like in every trial, just like how you'll have, experts, whatever the category is. It could be, differing opinions from a forensic pathologist or differing opinions from, like a psychologist or whatever the case may be. It's, we're always going to have this too when it comes to the digital forensics. And, we see this in a lot of trials wherever cell phones are at issue, right? Okay, so and in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensics axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and that still contains and shows the 2:27:40 a.m. search artifact, nor the several other digital forensics tools that Mr. Green used. Additionally, the motion of the Commonwealth is legally sufficient on its face. Oh, it was the artifact. So what happened to Kit Smits was that Mr. Whiffen, because he works with Cellebrite, he went back to Cellebrite here. He went back after the first trial right here, and now that's happened, and then they made updates. That timestamp, the artifact containing that timestamp, has disappeared from all Cellebrite programs, but it still exists with the other programs. So it's going to be now, and the thing is then it's going to be like, well, I guess what would be the strategy here is to try to be like, well, Cellebrite is the most reliable. It's the best of all of them. And the fact that it's not there and that's what Cellebrite says means that's what you should go with, right? But again, that's why, like they said, you should use multiple programs. And in the first trial, that happened because Mr. Green did, and so did Ms. Hyde. But then again, like we just read in Ms. Hyde's December 2024 report, now she's saying she's only using Cellebrite. So you've got Mr. Whiffen who's using Cellebrite, and then you've got Ms. Hyde who's only using Cellebrite when prior she was using additional programs. And then you've got now Cellebrite, that artifact is not there anymore. So you see where that's going, right? Okay, additionally, right, we already read that. Insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now suddenly after the first trial supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 2:27:40 a.m. search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed includes the same and entire methodology of the proffered witnesses for the Commonwealth, plus his addition of additionally accepted digital forensic tools. To prevent the continued abuses of Ms. Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. Okay, case history of the digital forensics analysis of the 2:27:40 a.m. search artifact. So, okay, let's take a look here. He stated, so here's the 5 digital forensics tools Mr. Green used to evaluate and analyze the data on the file. So Cellbrite Physical Analyzer, Magna Axiom, Belkasoft X, Sanderson Forensics, SQLite Forensic Explorer, and Artex. Those findings were consistent with the April 24th, 2023 report of Trooper Nicholas Guarino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Guarino reported that while the 2:27:40 a.m. search artifact did not appear on the version of Cellbrite Physical Analyzer he had used for his May 4th, 2022 analysis of Jen McCabe's phone, Mr. Green had used the then newest version of Physical Analyzer, which did depict the 2:27:40 a.m. search artifact. I remember that. And there's the browser state DB WAL file. Y'all remember that. I'm sure that was a whole thing. Inexplicably and unexplained up to this day, Trooper Guarino did not disclose in his report of April of 2023 that the Axiom program he used at the time did show the 2:27:40 a.m. search artifact. Oh, dear. Mr. Green's findings were further consistent across all 5 tools that he employed. Wow. And remain consistent with findings as of January 2025 from analyses performed in the most recent version of Axiom, which continues to report the 2:27:40 a.m. search artifact. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensics tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffin only used 2 digital forensics tools in his analysis of the data: Cellbrite Physical Analyzer, his company's tool Artex. I remember that. And all I could think about was Artex from The Neverending Story. Do you guys remember that? It's so fucking sad. Swamp Sorrows. No, can't even go there. So they're citing here testimony from the trial transcript here. Jennifer Hyde also employed this methodology, originally using Cellbrite Physical Analyzer, Sanderson Forensics. Okay, again, all these different tools. 4 of these tools were amongst the 5 used by Mr. Green in his analysis. In her May 2023 report and in her testimony trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffin that she had seen the 2:27:40 a.m. search artifact during her analysis. And then again, they're citing more testimony there. Inexplicably, Ms. Hyde changed her analysis and findings from her May 2023 report to align with Mr. Whiffin after a Cellbrite manipulated update to one physical analyzer program, which the defense learned about approximately 1 week before trial began, magically removed the 2:27:40 timestamp value from records sourced from the Safari's browser DB state. Using only this quote updated end quote Cellbrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back without explanation her original conclusion that the artifact containing the 2:27:40 a.m. timestamp was present on the iPhone of Jen McCabe in a deleted state. She opined instead that the artifact containing the 2:27:40 a.m. timestamp was not present in a deleted state or otherwise, citing nearly an unsupported, conclusory, and scientifically insufficient assertion that the timestamp was not reliable. Ugh. The Commonwealth simply makes the same bald, conclusory statement as Ms. Hyde, that further research shows that the timestamp was not a reliable source for a timestamp relating to the URL shown. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 2:27:40 a.m. search artifact and this artifact alone to be unreliable. It also provides no information about the methodology of that research or any other information regarding what changes were made, how, or why. Can we put Heather in timeout? Why would we put Heather in timeout? I haven't even seen Heather in a hot minute. Okay. So critically, despite the manipulation associated, no, don't do that. Okay. Sorry, I was talking to Adobe, but it can't hear me. Despite the manipulation associated with this unexplained update, in scare quotes, and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December 2024, does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 2:27:40 a.m. search artifact. In this second report, she employs the same methodology as she did in the first trial, and Mr. Green and Mr. Whiffin employed, but deleted, but deletes mention of an inconvenient Axiom tool she used in her May 2023 report, which is which as of the date of this opposition continues to show the artifact containing the 2:27:40 a.m. timestamp in a deleted state to reach a different conclusion. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensics data analysis. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all experts agreed and opined at some point during the first trial that the 2:27:40 a.m. search artifact existed and appeared in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools. Yup. It's right. The fact that she said this, I remember her saying this. I remember that. The fact that she said this in trial, it makes it even more insane that now she's submitted another report only using Cellbrite, right? But also, not only that. So in other words, it makes that look shady, but also it supports that Mr. Green is, if you're going to say which expert is maybe more reliable, if in fact at trial, the Commonwealth, presents Jessica Hyde and Mr. Whiffen, and they're only using the one tool and the one tool Cellbrite, it's going to be a big deal, right? Again, for the jury, if they hear, then when Mr. Green gets up there and it's like quoting the Commonwealth's expert back saying you should be using multiple tools, and who's the only one that did this out of the three, right? And when it's a battle of the experts. So in other words, this here that she said at the first trial, I think is going to hurt the Commonwealth and help the defense for sure. So it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. And doing so is absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company-based approach of Mr. Whiffen, to which Ms. Hyde now disquietingly has morphed. Wow. The experts' disagreement is not over the methodology, but rather their opinions on whether the 2:27:40 a.m. search artifact indicates that Jen McCabe conducted a search for Haas Long to die in the cold at or before 2:27:40 a.m. Contrary to the assertion of the Commonwealth, this is a paradigmatic battle of the experts. Literally what I was just saying. So I'm not going to read the argument, and in case you're wondering why, because we're going to hear it literally here in just a second. And so we can always come back to it, but I think it'll be nice to switch it up and go to the hearing, because we've been doing a lot of reading. Well, I've been doing a lot of reading, and it sometimes is nice to just take a little break. And so, it's going to be their argument. Again, we're going to hear this literally. And then it's probably just going to get to their conclusion and their conclusion. Yeah. So, okay. I do have, by the way, also, I was going to call him Kevin again. I'm so sorry, Mr. Green, Richard Green. I do have his affidavits. There's a revised and then there's an original. But again, I don't know if that's really all that important at this juncture, because, and we can go over it again. We can go over it if you guys want, but why don't we go ahead and hop on over to the hearing? And you guys, this was a very interesting one. I think most of it sort of in chunks, but yeah, I'm just going to have to unshare, reshare here. Okie dokie. Let's do that. Jump ahead. There's Bev. Okay, we have to hear the hearings, obviously. Goes without saying. Oh, by the way, if you guys didn't already see some of this today, the court feed on every court feed had glitches. It is what it is. Yeah, I don't know why, but that's what it is.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, Uniform County of Norfolk.
Yeah, I don't know.
Give your attendance and shall be heard. I'd say the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judges 22-117, Commonwealth versus Karen Reed. Can I have?
Oh my God, it's so silly, but it is what it is, man. Mr. Alessi's like really excited.
Hank Brennan for.
Oh, now Mr. Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert
I
Alessi.
literally have never seen that before. That's a new one for me. Oh my God.
Good morning, Mr. Iannetti. Good morning, Ms. Reed. Oh, good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the
Crash Daddies.
Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are
Oh my God.
really in that order.
The fact that and that was literally that was actually in their pleading. They called it debunked. That is that's Hank Brennan right there calling it debunked. I just, it's a lot.
Except I think we should start with
Yeah.
the non-party Gretchen
On
Voss's
every
motion
channel.
to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus
So
memo.
this has to do with this is sort of a third party here. Yeah, like how sometimes we have like the interested motion, like we saw this in BK, right? The motion for interested parties, right? So that's what this. So Gretchen Voss is like an interested party here because she did an interview with Karen Reed, and the Commonwealth is wanting to be able to use that interview at trial. And so the fellow who's about to, well, hold on, let me see here. Come up.
Signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor.
So Mr. Birchie, I don't know. So that dude there, so that's her attorney, Gretchen Voss's attorney. And so basically what it is that they have raised an issue here with providing and turning over Gretchen Voss's like notes and stuff of the interview, and just I think really anything related to the interview because we saw him at one of the previous hearings. He was stating that Miss Voss was being like harassed and threatened and stuff like that, and due to this interview and like for her own safety, pretty much like for her own safety, like to not want this to come in. So a different reason than maybe like the defense objecting to it. So this is him representing Gretchen Voss. And I forget which publication she's from, but I'm sure they will say.
Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes, and the text messages that involve on-the-record communications by Voss with Defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal. Or why it has
You are unmuted.
Oh my God.
to delve
That was
into
not
it.
me, as you
So
guys
the
probably
question before
know.
the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendant.
Right. And so that's the thing, right? So the thing is, right now I'm remembering, so that actual interview, right? Part of the issues that were raised by the Commonwealth previously was that there were times like in the interview where, because she had her attorneys present where like she would be asked a question and then they would like pause it and take a break or like ask her not to answer. And then a certain, she would come back and answer it and it would be like a change of topic and stuff. And so basically the part that the Commonwealth is wanting, they're saying that there's, information that was discussed in between those certain questions being asked, that would be important. And so that's why they're going after wanting to get Gretchen Voss's notes as to what went on that wasn't, part of the final product, right, after being edited for that interview. Maybe Globe Magazine, but why does Vanity Fair also ring a bell? I don't know. Is it Vanity
The
Fair?
stakes for Gretchen Voss
Globe
are
Magazine?
considerable. As she set out in
Oh,
the
maybe
second
it's
affidavit
Boston Globe. That might be what it is. Yeah.
submitted to the court with our motion for reconsideration. Her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade. And among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off the record nature of the notes.
And that's the thing, right? That's the difference, right? Is that the notes that are in question here are, off the record again, but like the problem raised by the Commonwealth was that it's clear that that's where the things are happening that could potentially be incriminating. And then the answers were like the watered down version or whatever.
This is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. Now, this is off the record. The kind of lubricant that allows a source to have a free and full exchange with a reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source.
It is an interesting issue, right?
Might be a frightened migrant, or it might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off the record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintain credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes, because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice.
First Amendment. And part of the thing here too that came up before is that the company that owns this publication is not Massachusetts. It's in New York State. And they have specific rules. And from what I recall, it's actually, they are more, oh, what was it? If I recall, they are more protective. There's more, yeah, that's what it is. They have more protections for journalism, right? For journalists and for this type of thing, to where that was one of the things that came up earlier, whenever this issue was first raised, like months ago, right? That because of the fact that the publication is like the jurisdiction, right, would actually be New York. They have, like, the rules are different there, and there's a much greater protections in place for journalists in terms of protecting, things of this nature, their work product, right? So.
I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it's a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, oh, that was a case like this one, that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out to the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews, when it applied the Massachusetts balancing test for mandating production of.
Okay, when it this is important. So when it applied the Massachusetts balancing test for the mandating production of reporters'
Notes, texts, and audio texts, audio recordings, it did not treat this confidentiality promise as a factor in the equation. That we submitted was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests would impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test?
Yeah, the balancing
Rule
test.
17 first set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentially relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection.
Okay, hold on. I'm gonna back this up. Just this is important because this we can, again, I love it when there's knowledge that we can take into other trials, right? Other situations. So let's back this up and we're going to break down what he's saying here.
Moving that in order to require production prior to trial, the moving.
Okay, so the Supreme Court ruled that in order to require production prior to trial, the moving party, and I think he says there's going to be 5 things.
The moving party has to show, number one,
Okay, the moving party has to show first.
the documents are evidentially relevant.
Documents are evidentially
Number two, that they're not otherwise procurable.
not otherwise. Okay, so first that the documents are evidentiarily. That's probably that. There's a bunch of errors on the closed captioning. Relevant, right? And that they're also, number 2, not otherwise procurable.
Reasonably in advance of trial by the exercise of due diligence. Number 3, that the party cannot properly prepare for trial without such
The
production.
party cannot prepare for trial without such production. And I'm just repeating it because I know the sound is also not great. That's just how the feed was today. But yeah, so number 3, the party cannot properly prepare for trial without such production.
Inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number 4, that the application is made in good faith and, critically, is not intended as a general fishing expedition.
Okay, so not a general fishing expedition has to be made in good faith. So there were four prongs there, not 5.
In short, the court was explaining that the special prosecutor in Nixon was required to clear 3 hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the defense.
Interesting that this has to do with Nixon, though, isn't it?
And sufficient preliminary showing that the subpoena tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the
That's interesting.
handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know if they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information has extra protection because as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information and therefore would have a chilling effect on speech. In LaRouche, identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number three was the resulting disincentive to keep outtakes, or in our case, keep notes. And number four, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. There will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the
There's
impression
a lot of like,
effective journalists.
a lot of hullabaloo, right? Have you guys noticed that there's like a lot of people coming and going during the hearing, which is odd. I mean, I feel like that's not usually the case. But if you guys like right behind, there's that sign there, it says like 25 on the wall. If you guys watch over there, there's been people coming and going. It's weird.
Are working as agents of the government or the defense. The fourth estate can only serve its role as a pillar of democracy.
There's another person.
The public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor.
Okay, so I'm going to skip ahead to Judge Bev's ruling. He's basically just going through everything in his brief, making a record, and yeah. Oh, and then there we go. Okay.
Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook,
Oh boy.
who I won't name, posted her personal telephone number.
Oh dear.
For everyone.
Doxing.
That post suggesting I'll call her right away. And she's received several strange.
Oh dear, that's awful. That's awful. I wonder who that was. I bet that's her. One of them ladies must be her.
Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Burt. In the amicus brief,
Okay, yeah.
or the memo that was filed.
I figured because she doesn't
this
look very happy.
I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication. With
I
the
actually
defendant.
have to say, I probably haven't said this too many times. I actually think this is a fair and reasonable ruling from Judge Cannoni. That is, and maybe it's because it's not the defense here, right? It's somebody else. Like it's a compromise in a way, right? Like he's going to have a chance to make redactions, and then have, they're going to go back and forth and kind of agree on what can come in. And it's she's going to make sure it's not anything that's like representative of Gretchen Voss's personal opinions or whatever, versus just like flat out, like, I'm going to take it all and whatever, it's all admissible. So I do feel like this was actually a reasonable, surprisingly. So we know she's capable of it, right? So there's that.
Observations, things of that nature.
Well, Brennan, there's nothing in the interview notes that is reflected in the story except architectural details, that there's a rosary on the bureau and the wall is blue, whatever it might be.
The wall was blue.
I went through the notes with this question in mind. Can you separate the impressions and integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a reporter for this, other than the fact that she's a reporter and she's done the investigative work already. That presumably the Commonwealth has already done.
Okay.
Thank you.
Thank you. Commonwealth.
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right. So I'll take this under advisement. Thank you. All right. So paper 442.
So she's taking under advisement. Yeah. So the defense, I would imagine, will object. That will be something that will. So in other words, what would happen next? Because they're still going to figure out what all is going to come in from that, right? At that point, once they've made that decision and there's the redactions, potentially the defense could file a motion to eliminate. But I doubt that would go very far. And the last resort would be objecting at trial, right? Even if they know that the objection is going to get overruled, it would be to make a record. So I would expect, if whatever it is that's going to come in, after they finish with the redactions, for sure the defense, if they feel like it does not help their case, then yeah, they will absolutely object. And I guess the whole point too, right, was that whatever was in the actual on the record, right, interview was considered to be neutral or whatever, right, or favorable for Miss Reed, but wasn't going to be inculpatory, right, or anything like that. And so, but when it comes to the off the record notes, then I would imagine that they will object, and and then if it's overruled, well, then that's preserved for appeal if she's convicted of anything. So she's going to take it under advisement.
This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ACA.
Crash Daddies.
I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a Chewy letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the Chewy letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Brennan's recitation of our conversation this morning. If it pleases the court, we did get
Y'all remember how his beard looked last time? It's a little bit that way, but it's less so with the side beard.
copied on that letter late last
Maybe
night.
maybe he watched and he was like, oh, I'll tone it down on the side beard.
We did last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we can have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was
So
thinking.
we'll do this next week and come up with
So more
proposals
next
on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to the Commonwealth's motion
Okay.
to exclude defense witness Richard Green's.
Now for the big one, you guys. This was exciting from what I saw today. I didn't see all
So
of it.
I have received a great deal of
Okay, Kevin
pleadings
Green slash
on
Richard.
this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
Okay, buckle up. So before he gets started, I have made comments for anyone who's been watching, like that over time, right? We had Hank Brennan had his first appearance, right? And it was like, yeah, great, seems awesome, blah. And I've made comments that over time we've seen, or I've noticed anyway, personally, a change in him in terms of his demeanor, his strategy, his tone, a lot of things. And in a way, it makes sense, right? Because when he was first getting onto the case, he even said, like at the very first hearing, he was like, I haven't even seen any of the discovery yet. I'm just getting to know the case, blah, blah. And it would make sense that he's like, I don't know. He was being very fair and he wasn't being overly dramatic or, I don't know. This is, we'll talk about it as he goes through. But then after a couple hearings went by, and especially like on the last one, right? I commented on how I noticed a distinct change in it was with him and Dr. Russell, right? Where it was like, oh, okay. And at this point, it's like, by that point, now he's seen the Commonwealth case and he has had to figure out what the strategy is going to be and whatnot. And anyway, basically, when it comes to the difference between like the defense and the prosecution, right? It's different because it is generally considered to be more acceptable in terms of for a judge, right? But also just in terms of the, like the practice of law, that if you're a defense attorney, right, there's certain things that are, whether it's arguments or strategy or tone, basically, it's expected in a way, right? That you're fighting for your client and, the government has the burden, right? And they're the ones that brought forth the charges. They have all the resources. And so, as it should be, defense is given more leeway in different respects, but in terms of just like, I don't want to say like playing dirty, but that's what there's like a stigma, if you will, right, that a lot of people would have about defense attorneys, right? And again, that I'm just saying that as like a stigma, right? And I'm mentioning this because for the government to then sort of toe the line, if you will, with some of those same tactics, it doesn't fly the same way because, again, they're the ones that have all the resources. They're the ones that brought the charges. You know, it's the defendant's rights that matter, right? And to do everything to protect the defendant's rights. So where it gets tricky for me with Mr. Brennan here, right, is because he's a defense attorney and here he's a special prosecutor, right? That where I get concerned is when we start to see, as we saw last time with Dr. Russell, when we start to see the defense attorney clause come out, which great, love it, love defense attorney clause, you all know. But he shouldn't be implementing those when he's now working for the government. It feels icky. And, you know, I feel like even a jury, without knowing any of this of what normally is acceptable or not, I feel like it might not, it might make, I don't know how it will go with a jury. But anyway, all that to say that keeping in mind he's a defense attorney, so we're going to see potentially some of that kind of come out again in this hearing, as we did with his cross of Dr. Russell. And we have to just keep in mind that it's like a defense attorney being a defense attorney is great and awesome and whatever, but like a defense attorney, if they're going to be delving into some of those different tactics that maybe are warranted when you're fighting for your client's life, it's different when it's coming then from the government. So just hopefully that makes sense, and just to sort of set this up. Okay.
May it please the court.
Yes. He's putting it simply. He's an asshole, in my opinion. There you go. There you go. He definitely didn't come across as an asshole the first hearing, right? Which is why I say it's interesting. He definitely, he's shifted more into the asshole realm, I guess, as these have gone along, in my opinion.
Mr. Green as a witness regarding 2 points. The first is a claim.
Lally, it wasn't just that Lally was lame. I don't know that anyone complained that Lally was lame. Lally was incompetent. He wasn't offensive, right? To me anyway, he wasn't offensive. I mean, he was just incompetent and kind of droned on and, you know, he was, you know, memeable, right? So I don't know about lame, but it's not one or the other. Like, the opposite of lame is not an asshole. The opposite, even if you go with lame, like again, I don't know that anyone said he was lame, but the opposite of Lally is not somebody who maybe crosses the line when it comes to, you know, the ethics of being a prosecutor and the interest of justice and the defendant's rights. Like to me, like again, in my mind, Lally was really, again, just more incompetent. And the opposite of that would be competent. Somebody, a prosecutor who's competent and fair. Like I have a favorite prosecutor, Creighton Waters. Y'all, I'm sure have a favorite prosecutor. You know, I know a lot of you guys love Georgia Kaplan. Think of your favorite prosecutor, right? Think of a prosecutor who's fair, who plays by the rules. Like, you know, initially, right, he said he's going to turn everything over for discovery. I hope he's been doing that. That's awesome. That was why I was like, awesome. You know, my impression initially was like, oh, so he's going to be really fair and blah, blah. And like if you look at Hank Brennan at those first 1 or 2 hearings, that for me was an example of somebody doing it right as a prosecutor, right? But it really shifted for me, at least as of that last hearing with Dr. Russell, where we saw him, you know, that was not normal. That was not normal for a Daubert hearing. And anyway, he really pushes it a lot from what I've seen. And I haven't even seen all of it, but we're going to watch it for this hearing today. And honestly, dips into even being dishonest. From what I heard, there were a couple statements in here that are actually like factually not true. And again, neither side should be doing that, but he's representing the Commonwealth. So, you know, hopefully that makes sense though. The prosecutor in the Ezra case, right? Mr. Dufour, loved Mr. Dufour. He was awesome. He was awesome. He was one of my favorites as well. Loved Mr. Dufour. Yeah, he's one of my favorite prosecutors for sure. And unless he did kick some ass, yes, it was freaking awesome. I was almost going to change the thumbnail and change it to like Alessi Slade, but anyway, yeah, I was like Slay, you know, yeah. Mr. Dufour, for anyone who has or hasn't watched that, yeah, the prosecutors, they did an awesome job, and they were very, very fair, and yeah, they were a great example as well. So yeah, but anyway, I don't think that it's one or the, I don't think it's like the opposite of, I don't think it's like either you have Lally or you have somebody being a prosecutor who's being dishonest, or, you know, I don't see that I don't see those being, you know, the two options there. So no, let me just go ahead and say here, Top Cat. So that's not true. And I know you're in Australia, so this is important though, because a lot of people have this misconception. I'm sure somebody in the chat's going to say literally what I'm about to say, but okay. The government does not defend the victim's rights. That's not it. That's a misconception. They're not defending the victim's rights. When the victim's rights would be, or when the victims would be represented is in a civil case. Like, let's say that and actually, I think they had actually started that, right? They were bringing a wrongful death suit. Then you have counsel representing the victims. In a criminal trial, whether it be federal or state, the government represents the people who pay the taxes in that jurisdiction. They don't represent the victims. Let's just make sure that everybody's clear on that. That is a misconception. And a lot, I mean, maybe that seems to some people how it should be. That is not how it goes. They don't represent the victims. They represent the people of the Commonwealth, not the victims.
Witness's phone made.
Thank you. Yep. Yep.
For a phrase to the
yep.
effect of,
He says the government prosecutes the defendant, has nothing to do with the victims. Yep.
how long to die?
That's for the civil courts.
7 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. This case, as the court proposed, potentially scheduled for next week. Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is that there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions, because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case.
Which that's shocking, right? Because they all used the same methodology, and he used more than the others. So right there.
Similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd, because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system.
He absolutely did. He did absolutely argue methodology with Dr. Russell. And I want to just say something too. I certainly, going through life, right, before I started really delving into law and studying law and all that, you know, like, for example, if this had been me 5 years ago or whatever, I 100% would have said, if someone asked me, you know, in a criminal trial, who does the government represent? I 100% would have said, oh, the victims, right? Because that seems, so I just wanted to say that it's a misconception, but it's an honest mistake to make, because it kind of makes sense, right, in a way. Like if you just don't know, and that seems like that's what it would be. So I just wanted to add that. But, you know, it's not until you learn otherwise that what is actually the case. So yeah.
Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. when you're using the terminology of a item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit.
So what he's doing here is he is suggesting that the defense attorneys wrote this.
Supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations, and surmise, and conjecture, and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any
Now, again,
raw data.
this is him misrepresenting the facts because, again, if you guys want to read through the affidavits, we can. I have them. I did actually read through those while one of the other PDFs was downloading. I scrolled through it and the thing is that that Mr. Green gives I keep wanting to call him Kevin. He gives several reasons. I think there's like 4 or 5 or maybe 6 reasons of why there could be this anomaly, right? With the cell phone extraction. One of them, could be something with law enforcement tampering, right? But he gives other options. He's not just simply saying it was, in other words, he's not just saying or alleging the only thing here could have possibly been tampering by law enforcement, right?
We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense.
I don't know what you're referencing, Twiz, but hi.
Mr. Green, prior to trial, stand behind these statements under oath. I'd like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common.
Again, for anyone who's
just
for anyone who didn't watch all this earlier, this is the court feed on every court feed. If it just glitches weirdly in a different way than usual. So anyway, that's not y'all, that's not me. It's a court feed no matter which channel you watch it on here.
Let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case. Mr. Green's going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing.
Again, I just have to say, all the experts used the same methodology, at least initially, and then this time around, it seems like the Commonwealth's experts are only going to be using Celebrite, while the defense expert is using Celebrite plus like 4 other tools. So it's just,
Considering testing in this case, there are certain tools that are used.
Here we go.
Defense,
Speaking of tools,
wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert.
oh, stop it. See, this is where I get pissed because he's like some type of race as if it's a contest, right? Come on, dude. We just read this. Y'all remember? Literally coming from the Commonwealth's own, and I'm sure that I don't have to make this argument. I'm sure Mr. Lessy will say this, but coming from the Commonwealth's own expert, as I pointed out, the Commonwealth's own expert was like, you should use more than one tool. You've got to be kidding me.
The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but
No.
an expert
No.
can interpret the X-ray.
No.
The data. In this case, Mr. Green in his affidavit.
This is not, you guys, this is factually misrepresenting literally what we know and what they know, what he knows about these different products. I mean, literally, this is where it crosses a line for me because the whole point of this entire fucking thing, right, is that Celebrite gave different results than the other tools. That's the whole thing that came out in the first trial, right? Celebrite produced a different result than the other tools did. So to say that they're all the same, just like an X-ray machine is an X-ray machine, that may be true of X-ray machines, but and I don't know enough about X-ray machines, but given that since he's providing that as an analogy, I would imagine X-ray machines are pretty much all the same. But that literally is the opposite of what we have here.
That's a huge number of things because he has a number of x-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that.
He's trying to say that all the different tools that you use to extract fun are the same, and that's really all just subjective, like in terms of how you interpret it. Well, it is true. Like that's the second part's not untrue. Yes, you can interpret it differently, but also there's differences in the tools, and that's why you're supposed to use multiple tools, as we learned from the Commonwealth's expert in the first trial.
He cites two opinions.
Right? Yeah.
His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engaged in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance to Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then has a last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell really for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual.
People coming and going.
This has been presented to the court. We've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time, and if that tab is reused, the original time will imprint. And so, certainly Mr. Green knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary.
None of this is relevant, by the way, for a Dauber-Lanigan standard. What he's talking about, again, this was even mentioned in the defense's response that we read. this is all fodder for cross-examination. This is going to be determined by a jury. Yeah. So, all right.
You see Mr. Whiffen and Ms. Hyde's reports. It isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information in a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that they would.
This is one of those things that I remember hearing, again, I heard bits and pieces. I remember hearing this when it was happening, and I was like, oh, that's interesting. So this is one of those things where, again, it sounds like one thing, but then you're going to hear more about this when we hear from the defense and what was really going on with that.
Number 16.
I know, right? I know.
Just look at this phone that they were two.
Sorry, guys.
The second opinion is an attempt, really, just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because, number one, doesn't have any resonance. Leading somewhere, somehow. Uncommon. The claim, or the opinion number two, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value.
That is a lot. That is
opinion number two.
That is a bold statement, saying that he's making these baseless claims and then therefore you should just assume that, like, what else is he willing to lie about? Like, you've got to be fucking kidding me. Also, this is this isn't even a Dauber hearing. This is a motion. This is the argument if they're going to have a Dauber hearing, and everything that he's saying is like literally you would save that for like a closing argument at trial. Like, it's just completely insane to me and rude.
This expert, so-called expert, takes the liberty.
Oh my God!
To say that
y'all,
McCabe's cell phone.
I forgot about that part. He said so-called expert. Hold on.
In opinion number two.
Wow.
This expert, so-called expert, takes the liberty.
That's a lot.
To say that the McCabe cell phone could have been manipulated. Not that it was. Not that I did a study. Not that I have a fact. It could have been manipulated. Then rehashed after.
That's better than
with the PDF.
That's better than saying it definitely was manipulated, right? Like, he's not full on blaming law enforcement anyway.
Being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It's because the claims he makes in opinion number one are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when we don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case. Because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it happened, he turns to police manipulation. And he says that there can be a problem where the hashes don't match. But the problem is the hashes do. They match.
Now, this is where it gets interesting in terms of overlaps with other trials, for example, BK. Because, you know, one thing that we have been talking about looking forward to at trial, for any trial where there's cell phone evidence, that's going to be a huge deal, is the celebrate, you know, the phone extractions. Y'all have been hearing me talk about this. And so this is where it gets interesting, and the hashes, right? And so, and to that end, everything that they're even discussing here, right? Where you can have different experts, you know, take away the specific, it's a Hoss-Long search, right? It could be anything. It could be literally anything. We see this again in every trial where you have cell phones that are at issue, where you've got, you know, you're going to have people who, again, they are all qualified and they do the same, you know, methods, and they take a look, you know, and it's like, but there could be a discrepancy somewhere, or they could just come to a different opinion. And that's just like with every trial, how you have experts battling for any specific thing. And so we're getting to learn a little bit more about how that plays out when it comes to these phone extractions. And in the first trial here, you know, the differences and the discrepancies, you know, where it was really pertaining to the search, right? But what's interesting in that we learned more about today was, especially for Mr. Lessy, was that the hashes, the hash marks. And that's really, really important. And I don't think that came out at all in the first trial. So again, information that we can take going forward into other trials.
He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be
a different universe. Come on.
And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, in the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic.
So again, and important here too, manipulation, right? Was the phone manipulated in terms of when when it was being extracted? Was the phone manipulated? But I am in the process literally of replacing the batteries in my goat, and I'm probably gonna have to back this part up so we can go at it. But yeah, anyway.
Went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just pause it, hand grenades throughout the case, and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all.
Oh my God.
I can go through each one of them.
Oh my God. Oh my God. Conspiracy. Did he just say that? Hold on. I just had to find a teeny tiny little screwdriver. Let's see if I can. Here we go. Here we go. Okay. I can't handle this anymore. I have to have the goat. So we're getting this teeny tiny little screw. Almost there. Woohoo! The goat is going to be coming back to life, guys. Get excited. Okay, good. We're making progress. And so it's got 3. I'm just going to put these little batteries in. Oh my God, it popped out at me. Scroll battery replacing sesh here. And I'm almost done. It'll just take a second. Figure out which way these are supposed to go in here. Okay, that's the negative side. How do you know? These are teeny tiny little dudes. Okay, so they go this way. Okay, almost done here. Actually, I need a couple more of these. Well, I'll just play it while I'm getting these batteries done. Jesus.
I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify.
You're not asking for that.
To the court why he did not engage in methodology.
I find that odd.
He has come to these extraordinarily
Because the
baseless,
defense is not
inaccurate,
asking.
and
Oh my
prejudiced
God.
claims.
Don't worry. We're going to go at this. I'm almost done.
Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology.
Okay.
This is the way to
Thank
address
God. Guys, we did it. Listen. Hold on. I'm so excited. My goat has come back to life. Yay! Okay. So first of all, I have a number of things to say. First of all, I wonder if anyone else that has this goat, like on LawTube or anywhere, has like replaced their goat batteries. I've not heard anyone talk about that. So that's the first thing. The second thing is that it's odd to me that he keeps mentioning wanting to have a hearing and includes the Commonwealth's digital forensic experts in that. Like, it's odd. Why? I don't know why he's asking, like, what? Like, the motion for a Dauber hearing is just for the defense expert. Like, they haven't raised the same issue. They've not asked for that. It's odd that he wants to bring them in as well, like his own experts. I've never heard of that. And that is very odd to me. And I'm just securing my screw here so that my goat is very happy and safe and sound with his new batteries. Okay. So now I'm going to back it up just a teensy bit here because there's a lot going on and we need some goating as well. So, the goat is risen. Yes. Yep. We did it. Right. The conspiracy part, right? It's just, oof.
He lists a number of what he calls anomalies, which are really not anomalies.
Okay. We're close to where I wanted to be here. All right. Well,
Spell his own claims. It's either he doesn't understand the forensic technology.
where did I get the goat? So hopefully, so you guys are probably familiar with this goat because a lot, EDB was probably the first one to have the goat, and then kind of spread all around LawTube. So Kit Smits, who happens to be in the chat right now, perfect. This is the perfect moment for the goat to rise because Kit Smits, we were there was a live stream and I forget what we were covering. Do you remember Kit Smits? But it was I don't know, maybe a year ago or something like that. And Kit Smits was like, you need to go, because I kept saying I need to go, and she was like, you need to go. So she sent me we looked online, found where can you get the goat, and it's the same. I have the same exact goat as EDB and Runkle and everybody else has the goat, identical goat, and you get it on Amazon, and it's I don't know, it was like $10 or something. So anyway, so she sent me a super chat, and it was specifically for the goat. So I got the goat, and so yeah, it's my goat actually is missing an ear because I dropped one time. I was goating so hard that I dropped him and one of his ears broke off, and I looked everywhere for that ear and I couldn't find it because I would have glued it back on. But you know what? It just gives him some more character and he's totally fine. He's okay. He's all good. He just wants to have his voice, and now he's got his voice back. But it is it's sometimes I call it my comfort goat because I'll just if I know I'm going to be goating, I'll just hold the goat and I hold it a special way. And it's become a little comforting thing, the way that I hold it. Anyway, it's just funny. How people have their little, sometimes people have their, what do you call it? The things that you hold that you mess with. I've never had anything like that really, but I have developed that with the goat for whenever I'm especially oh my God, the BS, and my comfort goat. And a couple of times I've poked myself in the eye with the goat. And I go, my eye. So yes, the goat is amazing, and you can get yourself one on Amazon. Fidgets, right? That's what I'm thinking of. Thank you, Kitsmits. Yeah, I think it was maybe during Det v. Heard sidebars, maybe. Because I feel like I did have the goat for some of that, but yeah. Don't do the eyes are important. I know, right? Good point. Facts right there for sure. Facts. But you know what? Now that it's the ears are pointy, and that's what I poked myself with. But now that he's only got the one ear, my odds of making myself blind on accident from goading too hard are have decreased. They're cut in half because now we only have one pointy ear. So okay, excellent.
Or he chooses not to do it, so he can just pause it, hand grenades throughout the case, and let them resonate.
Hand grenades. You've got to be. Hold on. This is what this is for. Y'all.
They fall.
No, like
in an attempt to create some doubt or uncertainty or merit some conspiracy, he makes a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a different opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing.
No idea.
There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well.
You mean like what happened in the first trial? Y'all, I'm so happy right now that my goat has his voice back. First, I lost my voice, and then my goat lost his voice, and now we both have our voices back. It's awesome.
And he should explain to the court why he did not engage in methodology and how
you're joking.
Extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to.
Y'all hear somebody's car alarm going off?
Court rather has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. This is the
Stop it,
methodology.
dude.
Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There's no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to.
This is for a jury, you idiot. Dude, stop.
In fact, it changes. It has an unacceptably high known or potential rate of error. Hopefully see and read Ms. Hyde.
Again, that's the
It's
court.
just a high level of error. It's gross error. It's total error.
They use the same programs.
And is governed by recognized standards.
Right? Thank you.
So if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom for the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate.
He meant to say sideswipe. I'll correct that for him.
At every turn, positions of Mr. Green are not only unsupported, they're unverified. And so what arises from the subterfuge is that Mr. Green...
From the subterfuge? Is that like after the hand grenades? Guys, after there's been a battle zone. I don't even... After all the hand grenades have gone off, and now there's just some subterfuge. What arises like a phoenix from the ashes, y'all.
Really just a vessel, or an attempted vessel for the defense third-party culprit.
A vessel, he says.
It is not lost on me.
It's facts. Someone's been watching way too many World War II movies. Yes.
I'm mindful of the data on the phone being a certain
Hilarious.
telephone call that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions.
Oh,
around that
stop,
time about
dude.
how long she could drive home. Under the extraordinary climate of circumstances, in the depth of the amount of witnesses and information in this case, it is hard to think.
I mean, there were a lot of witnesses, but I don't know, quality over quantity. I mean, how can he say that with a straight face, though? Like, hold on, pause. Does he know about the solo cups? I mean, does he know? Did he, not know about the solo cups, for one thing, for starters, right? For starters there.
You wouldn't use a solo cup.
I'm sorry, what?
Objection, Your Honor.
Solo cup.
That type of thing. I've watched the entire trial. I covered the entire trial. And not only did I cover the entire trial, I also did recaps on top of that. And I think we finally got to where we were doing recaps and we were on like the last couple days of trial. And by that point, there was already a verdict and we were all too depressed to finish the recaps. But I covered the entire trial live and did recaps for all of it, except for like the last couple days.
That just happened by
right. And that's the other point.
That there is a inquiry, something forming in the mind of the accused is then shared with the witness, Mr. McCabe. And in response, she makes the search, which is entirely supported by all the credible forensic evidence. Mr. Green is going to be a witness in front of the jury in light of the fact that he has no methodology and he's wrong on the science. In addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense. He should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right. Thank you.
No, I'm saying, yeah, sorry. So as far as getting it wrong, I guess I can just address that specifically. Like, that happens with experts all the time, but nonetheless, that's not the point of this. If there was a Daubert hearing, right? Because this is not the Daubert hearing. If there was a Daubert hearing, that's not even the point of a Daubert hearing. Like the point of it, like I can understand why Mr. Brennan might make someone think that because of, again, the things that I mentioned before that are troublesome. He's arguing things that are literally have nothing to do with a Daubert hearing. A Daubert hearing is not about, did an expert get something wrong? Every expert's going to get something wrong, right? It has this method, has this field of expertise been validated and tested and been approved and used in the court of law before in that jurisdiction. Give you an example. Long Island serial killer, Lisk, Rex Heuermann, right? Kind of recently, there was a motion for a Daubert hearing filed by the defense as it pertains to one of the state's DNA experts with a hair, some sort of testing on a hair. And you might be like, what the heck? So it's not that this is a newfangled thing or whatever. It's a type of DNA testimony with hair that's been going on for a very long time. It's not that it's even a new type of science. It's not that the expert's not qualified. The reason for their motion is it's really just almost in a way a technicality, but this is my point. It's because in New York, no one has testified as an expert on that particular subject before. That's all. So now it has to be validated in that jurisdiction. So that's just one example. So the jurisdiction, or if it's a new form of expertise, right? That, like for Dr. Russell, the dog bites, that's why, right? It's really not so much about the expertise of the witness, although again, he would be misleading you to think so because he tried to do that with Dr. Russell and he's trying to do that here. While that can be the case, if it's somebody who's just like completely inept, generally with Daubert hearings, it's really more about the field of expertise. If it's a new area and has it been tested, is there a methodology? And again, has it been validated in that particular jurisdiction? So for him, for Mr. Oh my God, I want to call him Dr. Kevin, Mr. whatever. For Mr. Richard, what is his name again? Green, Mr. Richard Green. Oh my God. For him to get something wrong is completely irrelevant. And that would be something for the jury to determine how much weight they want to give that. And that is something for trial.
Mr. Lessing?
Hopefully that makes sense the way I explained it. Oh, I didn't even update this. Well, okay. Defense.
May it please the court.
Liz.
Mr. Green.
Right. Sorry, I'm just catching up on the chat here. Yes, need some Z's, opinions for the jury to decide. Yep. It's less about the conclusion the expert came to, more about the methods they used to get there. Yep, the conclusions for the jury to weigh. Yep.
Is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to Die in the Cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without...
So this is one of the parts I did see this before. I was like, at this moment, I was like, somebody's going to get their head torn off from Judge Bev. Did y'all see this? Somebody's phone's going off. Just wait.
Objection.
But they are being.
And right there, I was like, oh my God, that's Mrs. O'Keefe. That's who that is. That's Mrs. O'Keefe. Now we just see her back, right? But I was like, that's who that is. That's her phone going off. You know, normally, yeah, again, you will face wrath, right? If your phone goes off in court. Yep. Oh, the spinning wheel. I couldn't believe this at all, you guys. I could not believe what happens. Like, that was already, I couldn't believe it. And then there was even more, I couldn't believe it, coming up in just a minute.
Being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detailed
nuts, right?
Than what happened
Literally,
in the first trial.
It would never have happened. Like, this would never happen with somebody else, which is just, you know, it is what it is, but it's crazy.
In Mr. Brennan's argument, he did not make...
Judge Bev doesn't even say anything. She doesn't even say anything.
One argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in the motion...
Hello. Also, did you ever think about if you want a custom command, let me know. Needs and Z's, I think, has said she's okay. DB has said it's going to be one of his greatest decisions. He's going to take some time to really ponder it and think it over, which is hilarious. Love it. Love it. But welcome. Glad you're here.
That even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas.
And I was like, hold on. This is when I was like, let me back it up. Oh, come on, spinny wheel. This is when I was like, what is happening? Right now, what's happening is the spinning wheel.
Of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no...
Right there, I'm like, she's coming back in? What? What?
Challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology regarding subject matter.
Yeah, I don't know. I don't recognize her. And I also, again, I haven't seen Turtle Boy. I know you mentioned that earlier too, Twiz, but they've not really shown the whole gallery. I think they've just kept it focused on this one area. And I mean, to that end, they had enough trouble as it is with the cameras today in court. So we're not seeing the whole thing. But yeah, I don't know who that is. Maybe a sister. I don't really know much about. I know she's got like a brother, but I don't know if she's got another sibling. Kind of looks related.
And Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some I agreed to.
There's like
And
a
I would like
similarity.
to, Your Honor.
There's like a similarity in the nose and mouth that you can see that I've recognized with Karen and her family. Like the way that I figured out who her family was before before anybody ever said, which I don't even know that anybody does, but like I figured out who her dad was and who her brother was just simply because they all look, some families look really related and they're one of them. But anyway, when you see the dad, if he puts his head back up, which I'm sure he will, you can see I think she looks kind of related. So
Or use those
maybe
in a moment. The Commonwealth, in its oral argument.
Oh wait, yeah, I'm pausing it. You see what I mean? You can definitely see some similarities there. Look, she's looking right at us. That's wild. But also maybe a robot. That would be way more fun, wouldn't it? No, I wasn't saying it's Karen. I'm saying related to her, maybe. Yeah, I was saying maybe related to her. Yeah, I know that's not Karen. Obviously. I mean, I don't think she looks a lot like Karen, but I think she looks a lot like Karen's dad. And I think Karen's brother looks a lot like both of them, like the dad and Karen. I feel like I don't remember much about what Karen's mom looks like, but anyway, but you can see their similarities in this where I've got it paused, but she's staring us down though. So you might be right about the, that's freaking hilarious. That's freaking hilarious.
Just now, that there's no methodology and that Mr. Green does not articulate a methodology.
Dude, she's like trying to look at us. That's what. Does she know we're talking about her? Oh my God.
That is incredible to me because
right?
The opposition and Mr. Green's affidavit, in fact, are
it really is
with the methodology. And here is the key, Your Honor. While Mr. Brennan
now I can not look at anything else but watch what she's doing, and it's kind of weird.
Challenges the methodology. None of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenged the methodology. As a matter of fact, in their two reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use.
Thank you for saying what I was saying.
That's what I would like to go to now.
Get it, Mr. Lassie, get it.
Is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is
J. McCabe, so AKA Chen. You have to do the goblin, what is it, or gremlin voice?
Just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step one.
This is important. Banshee, that's the voice I was looking for the description of the Gen voice. It's a banshee.
To receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step one, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received.
And again, one of the things that I've mentioned, right, the 2 terabytes in terms of EK, right, the 2 terabytes, one of the things that I've thought about on one of the live streams is that, the 2 terabytes could just be the size of the thumb drive, right? Like it might not be because there's 2 terabytes of phone data on there. I know there's been reference to 2 terabytes of data, but also that could be 2 terabytes of data of everything. You know what I mean? Like, because it's hard to pick. It is hard to imagine how a cell phone would have that, right? Like, anyway, but every time now that I hear people talking about USB thumb drives for doing phone extractions, I'm like, what's the size of that thumb drive? But they never say.
a full file system
they can't hear me, so.
of extracted data. So step one in the methodology that everybody agrees to, everybody agrees that occurred.
Oh, there was new stuff released. It must have not been there the last time I refreshed it. We'll go over that at the end of this. We'll go over that at the end of this.
2, verify hash signature value of image file of data received. This is very important because hash values with regard to...
Here's the hash value. So this is one of the things I was like, this is really interesting. And again, this could come up in other trials, right?
Forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations.
So this is really important. And this was also brought up in terms of the video from the Lallyport too, right? The hash value, right? That is how you know it's not been fucked with. That is how you know. And, again, in other trials, we have heard them, like, for example, in witness testimony, they'll ask, like, has anything been altered in terms of, like, during the phone extraction or whatever. And they'll say no, probably, hopefully, right? But this is sort of the behind the scenes of how is that actually tested? Like, how is that figured out, right? It's so this is, again, like, I don't know that I've ever heard this particular what do you call it? Like, element of determining the credibility of a phone extraction. I don't think I've heard that brought up in a trial, and I don't know that it will really be now maybe it will be brought up in this trial, but in other words, this is more like behind the scenes, like, how do you get there, right? But the hash value, so this is very interesting. And we've seen this in other cases, like, you'll hear, like, metadata, for example, like how do you know the thing, but here it's hash value, but similar idea. And how do you know it is legitimate? And so again, I just think that this is going to be something that for us to keep in our knowledge brain, the center of our knowledge brains. That's not even a thing going forward. In other trials and in life, I guess, in general too, of, like, but mostly related to trials in terms of, I guess, sort of, to me, here's the thing, right? Like, so generally I feel like there's a lot of trust in a cell phone extraction, like, it is what it is, blah, blah. But what we are seeing, and this is true with any developing technology, right? And especially as it becomes more important in terms of the trial process and relied upon, and it's going to prove or disprove a case, right? And again, as there's different programs that are happening and there's developments in the technology and whatnot, what you see is what we're seeing here, which is where there can be discrepancies, whether it's within the specific software, like the Celebrite version, right? We already talked about that, but also then you're also going to have, well, what if somebody fucked with it, right? What if somebody messed it up on purpose or on accident, all that stuff. This is where the hash values come in. So I think we're going to hear more and more of this type of thing now that cases are being pretty much completely built a lot of times on the cell phone evidence, right? It's going to be scrutinized more.
Without a basis. One of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is
Court feed. Court feed.
value, and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking.
Court feed.
Here's the key point. However, this requires authentication of the original hash value, which is not possible with great key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't validate this hash value because of the way Trooper Garino processed it.
So that's a problem, guys.
Do it, Mr. Garino, Trooper Garino, the right way when he got it. And why is this of concern?
Yeah.
Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2,
wow.
Trooper Garino only provides a PDF of the hash value. He used Gray Key, which was a mistake, because Gray Key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person. And the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffin concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And
I mean, just like all the other shit, right? Look at the Lexus. I mean, look at the red solo cups.
To the methodology. I want to go back to Exhibit 1.
Methodology.
So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffin, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each example.
Twiz, she's looking at you again. I'm a robot. Sorry.
Examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So,
and again, this is why, we're going to see this in all these other trials, and include, it's going to be really interesting that what, you know, we were talking about this too with BK, like we don't know much, we don't know anything really about the extraction. And I'm really curious to see who the experts are going to be for that. I mean, I really love in every trial. I look so forward to this, the cell phone shit, as you guys know. I look so forward to it. I think it's really interesting. And, you know, it's that's the big question mark for me. Right. And then we will learn so much, but what we can expect no matter what is this: we can expect that there's going to be people, experts, right, that are going to be using probably the same methodology, right? Hopefully they use more than one, as we know that's best practice. And, you know, reaching different opinions as to what the findings are. Now, having said that, if let's say there's a defense expert who takes a look and sees that there's some fuckery going on with the hash marks, then that's a whole different thing, right? Then it's like, then what we're looking at may not be legitimate. It could have been fucked with. That's a whole different thing, you know? But regardless, if we say, let's just hope that there's something intact, right? That there's something that's not fucked with, right? Because nobody wants to be thinking that law enforcement's going to fuck with shit, right? You know? So let's hope that it's not fucked with, right? Then let's just say it's intact. Then you're still going to have, you know, like what we're hearing about here, people taking a look and reaching different opinions. But that's what happened. That's what happens in trials, right? Battle of the experts.
Interestingly, it is Mr. Whiffen
who
provided the most lengthy report.
Yeah, right.
In this motion, Mr. Whiffen.
That's wild, though, right? Is it's like completely missing. There's not been a peep about it. It's just bizarre to me. It's absolutely bizarre. Again, I'll just reiterate for any of you guys who haven't heard this before, and I don't think anybody else has really pointed this out, which is shocking, but I've been harping about this since I realized this like a week ago. They have yet to say, by they, I mean anybody, literally even what type of cell phone it is. It's like, it's as if the cell phone doesn't exist except for as it pertains to the cell towers and the shenanigans with all that, right? And the white Elantra, which is still, again, leaves one wanting, like the information is wanting, right? As in lacking. But like, as in the actual phone, it's like as if it doesn't exist. It's like, and then when they reference it, it's just, they reference the 2 terabyte USB drive and no talk of who the experts are going to be. It's very weird. And I'm like, come on, people. Like, what are we, like, October is going to be here any second? Or wait, August, right? They're going to trial in August. August is going to be here even sooner. Right? Is it August? Yeah, it's August. I think I'm thinking October is when, October is when Shanna Gardner starts. Yeah. Okay. Let me back it up since I interrupted him.
Opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Cellebrite Physical Analyzer and his own software, Ardex. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
I appreciate that he enunciates very well also. Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier.
I love anything color-coded.
You see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools, exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Cellebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did.
Thank you, Tonka.
6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that.
Also, who else is in the same position where the word artifact is never the same for you now, ever since this trial? Like, it used to be in life, if I heard the word artifact, I'm thinking, oh, like Indiana Jones, right? That type of thing, like an artifact. But now, all I can think about is the DB wall file and Banshee. Jan! Also, I wanted to point out, thank you so much, Tonka, for that. But also, one thing I love everybody's so unique, right, in the Squirrel Crew and in the chat, and I just love it. One thing that really stands out about Tonka, I'm assuming I don't know, I should make assumptions. I don't know if it's he or she, but they take the time with every sentence to type out like complete sentences with the proper punctuation and capitalization. And it's really incredible because that is like not easy to do a lot of times. And it's like, I appreciate, not that it's, and I guess I was going to say not that it's necessary, but that's why I appreciate it. Right. Because, you guys see, I'll type whatever. And, in other words, I just appreciate that even though it's not necessary, you take the time to do that. It's something that is unique to you. So have you guys noticed that? Right? Who has time for that? I know. Right. And for me, it's like, if I'm on my phone, it's going to be a disaster. On my computer, some of my keys have been getting stuck really badly. Some of you guys have seen that. We're like, anyway, so it's going to be a disaster for me on pretty much any device, but that's what's easier about talking anyway. So, why don't people understand you? You guys are funny. But yeah, so, and Kits also does do a lot of complete sentences, I will say also, but sometimes gets lazy, as she's saying there. Yeah, it's good either way. I just appreciate seeing the different, the different styles. If you don't want to do complete sentences, I think you'll be understood here. I don't think you need to worry about that. But, whatever you want to do, y'all do you, right? Every scroll.
The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or in opinion, which is not the subject of a Dalbert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on.
He was such a distinguished young chap or whatever, do you guys remember? It's like he brought an air of class, if you will, or, what's the right word? Fanciness. What's the right word? After having heard from all the McAlberts, and like dumpster fires basically happening in court. And then he comes in and it's like there's different types of British accents, but his British accent is one that is really more old-fashioned sounding that you don't hear as often. And it's like from Downton Abbey or something. I don't know. Yes, thank you. That's it. Sophistication. Thank you. Yes, sophistication. And it was like, yes, I think I'll have a crumpet and some tea. You know what I mean? Anyway. And not out of a red Solo cup. I'll have it out of an actual teacup.
Lines 14 to question. And what, if anything, did you find with regard to the web history artifacts?
That's how you know.
Answer. This is Mr. Whip.
Sorry. That's how you know. When I heard that today, I was like, oh, he's reading trial testimony and this is on direct examination because that's how you know it's Lally.
Starting on lines 14 to question. And what, if anything, did you find with regard to the web history artifacts? Answer. This is Mr. Whip.
Yeah, I think
so the
you're right.
22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 22740, House Long to Die in the Cold,
House Long.
Mr. Green says it means what it says. The search occurred at that time.
Okay, I just was waiting for a good point to pause it. So typically, or Kimmy, I'll just call you Kimmy. So yeah, so thankfully no, because that was Lally. That was Lally. And Lally has become courtroom furniture. His new job, he's been relegated to the job of sit there and do your best impression of a chair. And we haven't even really seen him yet because the camera's been just staying put. But that's what he's been doing. And it's so funny because we haven't heard it at all. And now the only time we've heard it in months is because Mr. Alessi is reading from the trial transcript, which means he's reading from Mr. Lally. And that's where the what if anything happened. That's why that was so funny. And that's why it stood out to me when I heard it earlier, because I was like, oh, there's Lally, right? He's quoting Lally. So thankfully, and, I wonder, how before like Lally did the entire trial, I wonder if for this round coming up, it's going to be him. It's going to be Brennan doing the entire trial and Lally just sits there the entire time. Or if Lally's going to do anything. I mean, it doesn't look like it. It looks like he's literally just potato.
Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it. It's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 22740. That's the opinion that's disputed. So,
right. And I will say too, just real quick. So for anyone who's getting caught up, especially you, Kimmy, because you mentioned it. So, what happened is first the Commonwealth brought in Special Prosecutor Hank Brennan, who we heard from earlier, to take over. And again, Lally's just been demoted basically. And so he's a defense attorney, right? But he's brought in as a special prosecutor, similarly to Kerry Morrissey in the Alec Baldwin trial. And again, it's almost like, in other words, they didn't feel like there was anyone in their office that could do the job. So that's why they do that. So they spend all this money, blah, blah. And then the defense also added another, more counsel, which is Mr. Alessi, who we're hearing from right now. So they brought him in also as additional counsel. However, the difference is that they've not relegated anybody, right? It's not like he's not replacing anybody. But with the Commonwealth, it seems like, Lally's still there. But like literally, I think it was in the last hearing it was in the last hearing. Literally, I noticed a point where I pointed it out in the live stream. I was like, you guys, he hasn't moved in like a long period of time. Like you couldn't see him breathing or blinking. And I'm like, is he even like, are there any signs of life here? It's like, he's literally, that's what he's doing now. He's just, in his mind, like, what is he even thinking about? Is he taking a nap with his eyes open? I don't know. Is he dead or alive? But he's not doing anything. He's not even writing anything down. It's just Hank Brennan seems to be doing everything now. So,
fairness to the issue and accuracy, Those witnesses diverted at the end as to whether what that timestamp showed, 2:27:40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lally. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no.
There it is again. What, if any? That's how you know he's
I've done the
putting Lally.
Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I'm not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used.
And that's what I said when we went through the document.
Before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about under forensic.
So by the way, we did get a pan of the gallery there, and yeah, I don't see Turtle Boy. That's weird. I don't know why he's not there.
Analysis that she used It's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to, yeah. So
I'm happy to look at the report if that's what you're referencing.
I'm
Where
going to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 22740 still at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to 1 physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications. So they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite to Axiom to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's an opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now.
Something I appreciate about him is he's very easy to follow, right? His argument is very linear. It's very well thought out. And it's just, you know, he does a great job.
It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Celebrite Physical Analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Celebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Celebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Celebrite Physical Analyzer,
Thing is,
blah, 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 decoding engine, etc.
That is crazy, because that is not going to go over well at trial. Like, the fact that they had her do that is insane to me.
Is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AM ET timestamp, the determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis, and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite Physical Analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert. Yep. Because experts, almost by definition on each side, disagree on the opinions.
That is such a great point. Very well said.
We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Lallyport is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Lallyport hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person, and it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold.
That's powerful.
There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Pocomock Sports, and that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there is also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics, spontaneous. And he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where the search occurred. Well, that's interesting because a harder thing to load the image that came up with food did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date. I'm going to give you the specific one that controls.
No, I have both.
Okay, right. Yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both remain
I was just
docketed.
going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of Physical Analyzer on the market at the same time. One Physical Analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to is Mr. Green qualified?
That's smart.
There's not even a contest. Second.
That's smart. So he's citing the case law that she relied upon previously. Excellent.
Is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen.
Yeah.
I've never heard of that happening in a Daubert hearing.
That's what I said.
One party challenges the witness of the other.
Yeah.
And then says, no, by the way, I want to bring in my witness to show. That never happens in Daubert. It's
Yeah.
the person.
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow up, Mr. Brennan?
I do. A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffin's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone. For the user
Not
experience.
cache,
So
it's
there's
cache.
items that are available without
Cache,
connection that
not cache.
register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple. It can be explained. It's science. It's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool. You can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag value? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just pause it in theory. The government offers to bring in Jessica Hyde next week or even at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor,
No.
this is a difference of opinions.
Bam. Let's hear that again. Sick. And by the way, watch Mr. Yanni's face when he says this.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
Awesome.
With regard to the whole
Get
premise
it.
and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a doubt hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been won.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep next week and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along, try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wilkes as a neurologist. I'm waiting for his report. He is away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right.
The analysis is done. The accident reconstruction is done. Mr. Crosby with expertise in bites and dog bites. His reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It's all been base numbers. It hadn't been before. It's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery.
I wonder if that's Trooper Proctor's phone.
This morning to the defense, if they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another reduction as well. But we call it Rule 14 because it's not necessarily statements of witnesses, but again, I take a very, very liberal and broad view of what I would potentially want if I was defending the case. And I provided that again on the seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have the discovery meet 30 days,
So-
which will be next week.
Credit where credit is due.
I also
I'm glad he's again, he's making good on his earlier promise to be very transparent and in turning over discovery. So that's awesome. But I wonder if the phone that he was just talking about, I wonder if that's Trooper Proctor's phone, because we heard that was happening, that his personal phone, I guess, was going to be looked at, I believe is what it was. And that was a while ago, but I wonder if that's what he was referencing there with, he said a cell phone, he didn't specify.
what we filed, I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that as an important notice that we had sent in, because I am greatly respecting the issue of trial date, and there's work to be done. And so I would like to address that motion to clarify when appropriate with the court.
I do think she likes Mr. Brennan better than Lally, but having said that, I mean, pretty much anybody would be better,
Yeah, I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses.
boy.
from Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this.
Yeah, I mean, the judges will say, there's a question here, do judges really say don't be long-winded? I mean, yeah, in so many words, whether they say it that way verbatim or they, express that same sentiment in other ways. I've heard that countless times.
All right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant.
We just read that.
Filed on January 23rd. So more than a week ago, in the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving.
Get it.
Well, I'd like that filed next week so we can hear it next week.
Oh, boy.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all discovery. And I think it would be premature for us to figure out exactly what the parameters of our.
So that's interesting. He's saying that they haven't received all the discovery. And then as I was just complimenting Mr. Brennan, he's like saying they turned it all over. So that's interesting.
This are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
Also, for anyone who missed it, there was reference in the previous hearing before this one, when during Dr. Russell Daubert, there was reference. Hank Brennan mentioned Kenny Kinsey, so it looks like he might be their new accident reconstruction specialist.
So you expect to have everything to the defendant by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And Ms. Hyde has a report regarding a phone.
A witness interview that's inconsequential. Then why are you using it at trial? Like, and also, how are you to determine that it's inconsequential to them? But anyway, if it's inconsequential, why are you using it?
That's all that's really left for discovery. So that's all I can say.
All right. So if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
we've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not. The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
there's no strategy for us waiting. I promise you.
Be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. Time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into
really
play.
shocking that the Commonwealth filed an opposition to pay those expert-related expenses, because that's like a no-brainer. That's crazy to me. I'll take a look and see if that's up yet. I doubt it, but what the fuck are they going to say for themselves on that one?
And why there was a violation.
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there. For
What the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
So put
a little bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information for such egregious conduct.
Sure. Okay. I'll submit that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before.
No.
The motion for clarification should take probably less than 20 minutes.
Y'all, guess what? I got it. I found it. I don't think anyone's even covered this yet, because I think this just got I just found it. I found it, the Commonwealth's opposition. So we will cover that, and then we will cover the new BK docs.
Okay.
After this is almost done.
The motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding.
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything in Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to dismiss.
I'm sorry. The motion to dismiss on which Monday or Tuesday?
After we meet next week.
The following week.
Yes. I just want to get a scheduling order going, so I need some of these dates because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss. And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week.
Wow, so it's going to be a lot happening here then. Thursday and
also
Friday
going to
next
have to-
week, and then
Does
again,
the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can
All
safely
right.
say yes.
So February 21st, and I'll put this in writing, filing of all evidentiary motions, that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Your Honor, that week is school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right.
Yes, sure.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
there's Lally.
We'll put all our effort.
Oh, there he is finally. This is like, I think, the first time that I've seen anyway that they've panned over to the prosecution table. So there's Lally practicing his furniture impression. He's doing a great job right now imitating one of those chairs.
Do it if we have a problem. We can let the court know.
Okay.
We'll do our best.
Okay.
Look at him. A+.
All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th.
Tuesday the 18th, motion to dismiss hearing. Big day. Big day, people.
Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and or 5th. I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get ready for trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So
Motions to suppress.
Wow.
Wow.
Can
That
you all
has
come back in on March 7th?
Wow.
You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
You want to do with those filed by the Senate, all motions eliminated filed by that hearing date, the Senate?
Yes. On the 18th, which only gives me 2 weeks to decide them. Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic about getting us as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later. All right. All right. Anything else we need to discuss today?
Not on behalf of this reading, thank you.
No, thank you.
Okay. All right. Thank you all.
All right. So that's it for this hearing. So, but they've got a lot coming up pretty crazy, right? So Thursday and Friday next week. And then I think she said they're going to be back the following week. And then we heard February 18th for the hearing on the motion to dismiss. So a lot going on. And so a couple things here. All right. So I have it, guys. Let me pull my banner down. I have the Commonwealth's opposition, which, as Judge Bev said, was just filed that same morning, this morning. So I have that. And I had already heard also, I don't think it's out yet, but I did see that Judge Bev has already ruled on this, motion for a Daubert hearing for Mr. Green, and she has denied it, which is not really all that surprising. Although with Judge Bev, it's, you just never know, because usually she's going to always do whatever is it's surprising in the sense that the Commonwealth got denied, but it's not surprising in the sense that it was, obviously it was clear, like that's not relevant here. So, so that has happened. But let's pop on over. I know, right? Well, I know, right? What if they dismiss it? I know. So let's pop on over to the Commonwealth's opposition. It's not long. And then we will take a look at the new BK documents. So let me unshare, reshare as per usual. Okay. And I don't need to have this box up here anymore because there's no more law and crime logo. Okay. So here we go, guys. Lots covered tonight. We've gotten through a whole lot. All right. And the best thing of all, we fixed the goat. The goat is goating again. So, all right. So Commonwealth's, again, this was just filed today. Commonwealth's opposition to Defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth comes now, the Commonwealth, in the above captioned manner, and opposes the defendant's motion, blah, blah. The defendant's suggestion that the Commonwealth misled or induced the defendant to incur costs to have an out-of-state expert travel to the Canton Police Department is a distortion of the facts and has no legal merit. The Commonwealth requests the court deny this motion without a hearing. The Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of this case. At no time has the defense ever made a formal preservation request. Again, that's not the standard here. In November 2024, the defense made an informal discovery request relative to additional Canton Police Department videos. Special Assistant District Attorney Brennan responded on November 25th, 2024, informing the defense that he would inquire of the Canton Police Department and/or keeper of the records to attempt to identify any potential chain of custody of video footage provided and would request any documentation that may exist relative to the chain of custody of surveillance video. During the week of December 1st, 2024, ADA Brennan spoke by phone with Attorney Jackson and his co-counsel. Attorney Jackson asked if the Commonwealth would consider allowing a defense expert to access the Canton Police Department's camera system. No motion or order had been allowed or even filed relative to this request. ADA Brennan agreed to accommodate the defense's informal request. During the phone call, Attorney Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared Attorney Jackson's concern given the passage of time. Attorney Jackson requested the Commonwealth refrain from accessing the system prior to the defense expert's examination. ADA Brennan met with CPD Chief Rafferty and received permission for the defense to search for video from the Canton Police Department's DVR system relative, so there's a typo up there, it says NVR. Anyway, DVR system relative to the storage of the defendant's vehicle. Pursuant to Attorney Jackson's request, ADA Brennan directed Chief Rafferty to advise her staff not to disturb again, it should be DVR video system prior to the defendant's expert examination. ADA Brennan also invited the defense to tour the entire CPD station and note all camera locations. ADA Brennan informed the defense that the Commonwealth would have a forensic examiner from the Norfolk County District Attorney's Office and Massachusetts State Police trooper present. The Commonwealth videotaped the procedure to memorialize the event. Memorialize. The defense expert visited the Canton Police. The Canton Police Department on December 12th. It was learned at that time, nearly 3 years after the incident, that the footage on the DVR was overwritten and the system no longer maintained the original surveillance footage. I don't see how this helps the Commonwealth. Like, they're saying, like, literally what the defense said. Moreover, in efforts to identify video footage and chain of custody, ADA Brennan visited CPD, viewed camera locations, and had a discussion with retired Sergeant blah, blah. This retired Sergeant blah, blah served as the officer who originally obtained and produced video from the CPD. Sergeant blah, blah informed ADA Brennan that he routinely would make a copy of footage obtained from the DVR and preserve footage on the department's work server / hard drive, which is separate from the DVR file system. Prior to its mention for costs, ADA Brennan informed defense counsel. Also, that's a typo because the comma should come before the quotation mark. Anyway, ADA Brennan informed defense counsel during a conference call that retired Sergeant blah, blah would routinely save video copied from the DVR onto the, they made that typo a lot of times. That's insane. DVR onto the department's hard drive. ADA Brennan offered to produce a copy of the stored footage from the CPD's hard drive or alternatively allow the defense direct access to the hard drive. The defense deferred this offer and has requested further information about the hard drive storage that is forthcoming. The Commonwealth never suggested that nearly 3 years later, on December 12, 2024, the footage would be stored on the DVR system, nor did the Commonwealth in any way hinder the defense's desire to have a defense expert view the CPD DVR. The footage simply no longer exists on the DVR because of the time. This is not going to help them at all. What do you guys think? This is what? Oh my God. Oh, so is Lisa referencing something specific here that you're also referencing, Tonka? Because I don't think I was privy to this. I'm just not sure. Wow. I don't know how this helps them. Like literally they're basically saying essentially what the defense is saying. I don't know. Odd. Oh, it was sarcasm. Okay. Gotcha. That's funny. Okay. I'm just like blown away. Like, hold on, let me go back. I'm just like, what? Let me go back to the first page. So, because they go about this whole thing. There's a lot of discussion about how they make their communications, and they're going to inquire and request any that, chain of custody. They spoke back and forth. God, like, look at all the steps. Like, they're actually outlining all of the steps that were taken. Like, this is what's so funny. They're actually giving more detail about the specific steps that were taken to make this visit from the expert happen. Like, this was not even in the defense's motion. And they're outlining all of this now, all of the steps and all the different people that were communicated with regarding this visit in the effort to see this video. Like, this is what? Like, if anything, this makes it worse for them. Like, it's like, okay, so now all these people got involved. We were all going to make this happen. Like, this was a blah, blah. And it's like, now after all that, like, in other words, this is like even more effort, right? And then it's just like, oh, it's not there. I don't even have any, no one knows, Kitsmits. I don't have the answers on that because it just doesn't make any sense. Okay. So now let's pop on over. I just have to unshare, reshare. This is basically where we live these days. So, all right. So this one's new. we don't need it zoomed in that much. Jesus Christ. Okay. So it seems like Heather was saying something about, like last night, that she thought maybe there was something about there's going to be another Franks hearing. So, and I didn't read it that way anyway, but let's see what this says. So notice the filing list of stipulated exhibits for motions to suppress and motion for Franks hearing. So the way I interpreted this, because all we had was the title last night, the way I interpreted this was the motions that they were, or sorry, the exhibits that they were referencing, right, during the motions that happened last week, right? The hearings that happened last week, that these are, you know, the stipulated exhibits. So, what? Oh, hold on. Okay, here we go. Okay, so yeah, it's the exhibits list. So that's what I thought, right? I mean, it's not a new Franks. I don't think they can even do that anyway, but that's fucking hilarious. The computer just wrote over the good parts. It was an act of God. Hilarious. Yeah, I know. An act of God, right? Okay. So, okay, interesting. So here's a list of the exhibits. Email communications, interesting. And which pleading? Wow. Okay. Email communications between Detective Payne, Agent Balance, there's a typo there, and Latah County Prosecutor's Office. Email with attachment PC, so PC probable cause attachment from FBI Balance. They spelled Balance differently again here to Brett Payne. Email with working draft for search warrant for AT&T from Brett Payne to Balance. Exhibit A, statement of Dustin Blaker. Affidavit presented to a judge in Washington. Affidavit for search warrant for Google, January 3rd, 2023 warrant. Affidavit in support of arrest. Transcript for the motion to compel. So those are from the hearings on May 23rd and May 30th, which we covered. Actually, we've covered them more than once. Cast report, draft cast report, and then the final one. Affidavit of Tom Slavinsky. We don't know who that is. Hold on. That's a new name. Do you guys recognize that name? Oh my God. Okay. You guys, Tom Slavinsky. This dude. Cell phones. Is this going to be, this must, okay, hold on. I don't know yet. This has got to be a defense expert though, because I would imagine I almost said the Commonwealth. I would imagine the state's experts are, you know, law enforcement, right? Let's see. Okay. So his background and experience comes from 36 years as a police officer, detective, private investigator, mobile forensics examiner, cell tower records expert witness and instructor. Wow. Yearly certification in cell tower records, analysis, and geolocation. So it makes me wonder then, right? So if, in other words, if it looks like he has, overlap with Cy Ray, then this would probably be somebody being hired by the state because, you're not going to be able to have two experts that testify in the same field, like specifically. So like, in other words, the other defense experts, I would imagine, they're going to be maybe related to, well, definitely related to like the phone extraction and stuff, or maybe they could have more than one, but they would have different facets of that, but they wouldn't have another Cy Ray, in other words. So I'm wondering if this is for the state because, and the reason I'm saying that is because cell tower and geolocation. And so that is very much overlap with Cy Ray. So far from what I can tell. So, oh my God, he's licensed by SLED. My worlds are colliding again. You guys, what is happening? What is happening? How is it that Karen Reed, that the Commonwealth might be calling Kenny Kinsey as an expert witness? And how is it that in Idaho, they're having an expert witness, I don't know for sure yet, but probably from the state, who's licensed by SLED? My mind is blowing up, people. It makes you wonder, did all of these attorneys watch Murdoch? And if so, you guys, for anyone who's seen, a lot of the stuff I've been referencing with BK, we've talked a lot about Murdoch. We've watched some testimony from Murdoch. With Karen Reed, we watched some testimony from Kenny Kinsey, but with BK, we've been talking about the cell phones. We've watched a lot of testimony, and I keep referencing Murdoch, and people might be like, you're crazy, but tell you what are we seeing here? It's not just me, looks like. I mean, it looks like people got a win to Kenny Kinsey out there in Massachusetts and all the way in Idaho. And I'm telling you, I wasn't, I wonder if I can find the clip, because it's not just me. I mean, Bob Motta came on with Peter Tragos a few weeks ago, right, on the podcast there, talking about Delphi. And Bob Motta said what I've been saying. He literally said that, like, Murdoch, that trial broke new ground, being the first trial. Like, okay, what did he say? I wonder if I can find the clip. That literally cell phones were the entire thing, right? But even to a different extent than other cases. And he said what I've been saying and other people have been saying, which is like, it was the first trial ever to prove, time of death based entirely on cell phone activity. And so it makes sense, if cell phones are going to be a big part of the case, that you would try to learn from, but having said that, that's one of the reasons why it's so interesting to me that, like, again, as it pertains to BK, we've only just heard about the cell towers, but nothing about the phone itself. It's just really bizarre, right? So is it going to be really all about the cell phone? Do they have data? I mean, but SLED though, hold on. My mind is just blown right now, completely blown. Let's do the SLED command in the chat for good measure. He's defense. Tonka thinks he's for the state. So for a fact he's for the defense. Yeah, it's just that if he's going to be testifying about the same stuff as Cy Ray, you can't have two experts, for the same side, right? Testifying to the same opinions, right? It would have to be something different. For example, like if he does he do anything with extractions? Like, that's what I'm looking for. I mean, is he coming from South Carolina? Cell phone data retrieval. So maybe he is, let's see. Huh. Oh, if you want cell phone data retrieval, he says he recommends another place. So he doesn't do that. Okay. I mean, that's a cell tower. So I can't, interesting. Right. So the reason that they had two, I know, and that is unusual, but they had, so there was a specific reason. What was it? I think the way that they did that, it was something like Mr. Whiffen was supposed to be testifying more about, like, the timing of the search. And then I feel like Miss Hyde, she was really supposed to be testifying, if I recall, more about the proper way to go about validating or verifying how to conduct a cell phone, like how to do the extraction and how to interpret the records. Like, in other words, more like a general, like fact witness, if you will. Like, what am I trying to say? Like, not the facts of the case specifically, so much as how to do it correctly. That's sort of what I recall. There was some overlap, but it seemed like they had her come in to validate that Mr. Whiffen did it correctly. That was sort of my recollection, but let me know what you guys remember. But, and even that is still more on the unusual side. I mean, And the other thing is this, right? In other trials, that might not have flown, right? Like what would have happened is if the defense thought it was redundant because they already had an expert witness testifying in that field, they would have objected. And maybe they did. Again, I was not following that case pre-trial. I didn't follow it till opening statements, as many of you guys may know. But then it would have been Judge Bev maybe overruling that and saying, you know, as she is wont to do, right? But yeah, they fought over, like in the Casey Anthony trial, they fought over that a lot because the state tried to bring in, well, they did bring in the state. This is a good example. The state in that case, in their case in chief, they brought in multiple forensic anthropologists. And I think they had multiple of some other discipline, but I think they had like 3 forensic anthropologists, but the way that and of course the defense objected, and the way that they peddled that, the state, was like, well, one is testifying to this specific facet related to this thing, and then the other is like their testimony is going to be different. And again, when you've got because it's, again, in that case, a prosecution leaning judge, he let that in. In some, you know, if you don't have that, if you've got a judge who's maybe not so prosecution leaning, it could be a different decision on that because it is unusual. So, okay, thanks for being here, Kimmy. Hope to see you next time. Yeah, we're not going to get the autopsy result till trial. So I guess to that end, right? In this case, right, with BK, it would be up to the judge, right, Judge Hippler, to decide if indeed they were going to be testifying to some different facet. So again, and just because, unfortunately, because of the fact that most judges are prosecution leaning and not defense, that's why the only times that I can think of seeing that where you've got more than one expert in a similar field, the only examples I can give to that are Casey Anthony and Karen Reed, and those were for the prosecution. So, but they would be great. I mean, maybe it is for the defense. I mean, do you know that for a fact, Twiz, that's for the defense? Now, the other thing is this, right? The other thing is this. I will say that going back to this, it could be that they're not testifying at trial, but that they just provided, you know, because sometimes that'll happen where they review something, right? And so that could be the other thing. It could be that he's not going to be testifying at the trial, but they just wanted him to take a look at one particular thing and you know, provide an affidavit for this particular hearing, maybe. I don't know. So what is a cell tower examination? That's funny. Cell tower records are used to prove or disprove the actual estimated area that the phone was in. Yeah, estimated. Emphasis on estimated. Let's go to, I'm wondering, does he live in South Carolina? It blows my mind about SLED, though. Wow. Licensed by, I just can't. So this is the same as where we already saw. Spying. Many high-profile cases ranging from serial killings to murders to home invasions to corporate spying. I don't even know what that is. I mean, like, SLED. Yeah, I'm not seeing, though, anything on here about Celebrite. I'm only seeing shit about towers. Mobile spyware. Now, hold on. My brain's got so many things happening here at once. So services. Okay. Look, so when I go to services, so cell site tower analysis, litigation support, pricing. So it's really still towers. And the other thing is that so the reason I thought it could be either one is because in the hearing, right, which I have listened to so many times, I know you guys have as well, Ann Taylor, that crucial moment where they're talking about the discrepancy in the time and the towers, Ann Taylor says, she references affidavits and she says our experts, and then she references their experts. And she says, she uses it to support her argument because she says their experts that took a look said it was 254. Do you guys remember that? So that's why even if it's submitted or even if it's an exhibit that was offered by the defense, it still could be a state expert that they could be offering that exhibit because it supports what she's saying, which is, look, like even their own experts say they got it wrong. Because she says our experts and their experts. So there's that. First of all, so we need to figure out about the mobile spyware, so advanced cell tower geolocation forensic services. So I wonder if this is for the state. And so, because she says it in that hearing, okay, she's talking about how basically when their own experts, like she's saying, when our expert, Cyray, reviewed the cell tower data, right? And then she's saying their own expert reviewed it, as in reviewed the FBI cast, right? Like saying that they got the time wrong. It's 254. So I wonder if this is for the state. Oh, you saw extraction? Where did you see that? This is for Brian Koberger, kits. Unless, let me see. I missed some things here. Isn't South Carolina 14? I don't know what you guys are talking about, but North Carolina, if it's North Carolina, what? I'm in North Carolina. Strange report about the fort. I don't know what you guys are talking about. Something happened in North Carolina. Yeah. So we finished with all the rest of the Karen Reed documents. So we're on to Brian Kober. So let me hang on. Let me do this. I'll give you guys something else to look at while I pull this up. Yeah, CDR, call detail records analysis. Cell tower evidence and investigations. Assistance with obtaining CDRs. Cell tower activity reconstruction. Google geolocation activity. Google geofencing exam. Yeah, well, you guys can see that. Okay, let me pull this up. Oh, that's not the right thing. That's not the right thing. What? Hang on. Oh, that's why. Hold on. I'm just trying to find this real quick. All right. You guys will not be surprised at all. This is at literally the exact spot that we need anyway, because I pulled this up just like all the time. Like we just watch this all the time. This is what we watch now. Okay.
We submitted 2 affidavits to you from our experts.
Literally at the exact part. That's freaking hilarious.
Who have worked with the call detail records. And that's just not right.
So she said, hold on.
their cell experts report that say that
Let me back it up. It's so funny though. This is literally where it was from the last time I opened this.
the map we looked at earlier today, where there's the whole loop
Good morning, Beth.
around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that
Their cell experts report.
say the phone stops.
Now that's hard to tell. That could be either way. It could be expert singular or expert plural, right? Because if it's plural experts, but you're saying possessive, right? It could be experts. So she said their cell experts report.
Reporting at 2:54
So-
a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records.
Okay. So then that does sound like it's another defense expert. Because she's specifying there's 2 working with the call detail records. Interesting.
And that's just not right. Don't get caught up in thinking 7 minutes
Let's talk
don't
more
matter.
later though. Hold on.
We're talking about ground that can be covered
She references it again with the state's experts. Let me just go ahead a little bit.
close together a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Koberger is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going.
And remember, we saw in that presentation last night that the problems with handoffs, like, actually, I think I just finished the timestamp for that there's problems with handoffs. So
The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that phone wasn't traveling in to create a false narrative for the magistrate to rely on to find probable cause.
okay, so I guess that was it. So, okay. So maybe that was interesting. So yeah. Okay. So here's the possibilities then, guys, as it pertains to this dude who somehow is also like certified by SLED. What I see is this: either they're going to want to have 2 experts, testify about this at trial with the cell towers and CDRs, in the same, field, right, of expertise. Cyray and what's his face? What was his name? Hold on. Let me pull him back up. What was his name? Tom Slavinsky. Right. So either they're gonna attempt to have them both testify, but they're gonna have specific areas, right, where there is something different that they're testifying about, or it's just that they only were relying on this other dude, maybe potentially just to review the records and submit an affidavit, and without needing him to testify at trial. Either one, but I think that does sound like maybe he's for the defense there, given the way that she grouped their 2 expert affidavits back to back like that, the way she phrased it, that makes sense. So yes, glad you're back, Black Witter. Welcome. Good morning. I don't know anything about this double matrix. I don't know what that is. And I don't know what the 14 thing is referencing. I'm just trying to see. I have no idea. 14, like, yeah, Tonka, what is this now? About the 14, I have no idea. Okay, so but the thing, what was it that I was like, mobile? What was it? Hold on. Something with spy related. What was it? Mobile spyware discovery. What is that? So it looks like it's not something that's happening here. I'm just doing a quick Google search. It looks like in other countries, like in Russia and China, the governments are doing this. Wow, where they're like spying on people's phones. Smartphone spyware apps that allow people to spy on each other that are hard to notice and detect. Interesting. Oh, they've found this in Kazakhstan. They found it in Dominican Republic. Okay. So I don't know if that would be relevant for this case, but anyway. Okay. So, all right. So I think we've got that covered. So let's go back to the list here. Okay. Detective Gooch? Who the fuck is that? Okay. So we've got these different detectives, some, Maury, Nunez, emails with vehicle identification expert. It's still odd to me, right? And I mentioned this about the hearing too, that they kept saying this when it's like they've already specified it's Agent Imel. Like that's already a known thing. So like, why are you still like, it takes so much longer to say this. So like, why are we still saying this? And why is this still like this? Like, why aren't we just naming the person when it's already been said? I don't know. It's odd to me. Affidavit in support of search warrant UPS. Huh. Payne's instant message communications, Bolo. Supplemental report issued by Brett Payne retest runs. Sealed transcript. They got the sealed really? Did y'all know this? They got that never happens. That never happens. I'm trying to think if I've ever seen that happen where that's ever been granted. Wow. Supplemental report 152 by Officer Gunderson Reed. So Reed dog as in about the dog. Screen clip from Officer Nunez's body cam. Video of the dog upon arrival. Return on warrant. Doesn't say what. AT&T records provided pursuant to search warrant. Cellbrite report. Exhibit D18. This, that. So they relied on the Cellbrite report. Oh my God. What is in that thing? Dude. Oh my God. This is the first we are seeing anything about this, right? I mean, we know that it's done. It's just that's why it's wild that like literally, again, it's like the phone is like the white elephant in the room or whatever they say it is, or elephant in the room, whatever the saying goes, like it in many ways. And so this is a big deal. It's like, oh, okay. Like obviously this is going to exist, but this is the first we're seeing about it, which is the weird thing. Okay. The DOJ interim policy letter from Latah County prosecuting attorney dated 6/24/24 to Othram regarding databases searched. That's really interesting. Okay. Just this past year, transcript for motion to compel hearing, shoe print outside Dylan Mortenson's room, transcript of Dylan's interview, order on the fourth motion to compel, lab report 28, lab report 29, lab report 30, sealed letters between Latah County Prosecuting Attorney's Office and the FBI. Oh my God. Sealed letter dated 11/28/23 from FBI to Latah County Prosecuting Attorney. Interesting that that's a separate exhibit from the previous. I'm guessing that's a bunch of typos because it's probably the CV of the dude who we were just looking up. Sorry, cases, messaging with Payne. Lab report 127/23, FBI fibers hair, no connection. I'm going to highlight this. Can you guys, let me zoom in. Look. Wow. Okay. Right there, no connection. And then again, no connection. So remember how there was a lot of people speculating about the hair? Well, there you go. No connection. Biology analysis notes, photos, negative blood, DNA, S.A. Hill. So we heard about him. His name is brought up once from the hearing on May 30th about the videos. Another screenshot from Mitch Nunez's body camera. Wow. I don't know what that is, Tonka. My, their words. I don't know what that is. Right. I mean, I think that and I'll have to go back because I was teaching. I wasn't able to hear all of Andrea when she was live today, but it was really funny because there was one of the moments where I finished a lesson and then I came back and in the middle of the live stream with Andrea Burkhart. Literally, I came back in and it was at the very moment she was saying what I've been saying, which is like whatever she had just heard in the hearing. She like paused it to comment and was saying that she was like saying how this means the cell phone was off. She was saying this is like confirming, and I don't even know what she heard because I joined when she was making the comment, so I have to go back and find it. But whatever it was that she had just listened to, she was like, oh, that confirms that like it wasn't airplane mode, it was off. And she made that comment before Ashley Jennings says it was off. But anyway, the reason I'm mentioning that is because, you know, whatever it was, she got the same understanding from something in that. If you guys were, I know some of you guys were there, let me know if you remember what it was. She got the same understanding that I have, which is like, I think the phone was off. And so that's one of the things that, you know, I know that was the phone just out of the network because it wasn't, you know, it was not reporting to or was it off? And so anyway, that's the first person I've heard comment as to feeling like they can say that, you know, definitively that they feel like whatever she heard made her think it was off. Oh, okay. Yeah, well, that's okay. If I wouldn't have known what it was anyway. My 3 words, I never heard of that. I would not have known what it was anyway, so it's okay. So yeah, I mean, I don't know why anyone would be saying anything negative about Andrea. She's a highly skilled attorney and qualified to comment on these matters. So anyway, so I don't remember what she said. I'll have to go find that. But yeah, I mean, and the thing about the phone being off is this, right? Is that if the phone was off, again, like I've said, it could be that the battery died, right? It doesn't mean it was done intentionally, right? But if the battery died, that will, again, we wouldn't know this now, but it would log an event in the, you would see that in the Celebrate report. It would log a power event versus just being powered off. Now, again, you know, the Celebrate report is that's how they will know. That's how they will know if it was on or if it was off. Because if it was on, but it was just that it was out of network because it was too far from it, we've talked about this a million times, so I'm not going to even go through it again. But yeah, that's for many reasons, that will be very obvious when you take a look at the Celebrate. And let's just say that they theoretically, right, hypothetically, that, okay, take a look at the Celebrate, okay, and let's just say that what the Celebrate tends to show or is showing, right? Let's just say, for the sake of example, that it's showing that it looks like it was powered off, not from a battery event, but powered off. Well, that doesn't mean that's like, you know, if for some reason the defense wants to say that the phone was not off, right? Like, that's not the end of that, because then you could have, again, like we just heard, it may be, who knows, right? It could be that there's some issues with the extraction, right? Looking at the hash value. Was it fucked with, right? There's that as well. So anyway, just there's a lot of possibilities still with all that. Right. I know that's what's in the PCA, that it lost connectivity. I mean, what's in the PCA, we can pull it up. What's in the PCA? Let's just see here. I actually there's not much to appreciate about the PCA or Brett Payne, obviously. But there's one thing I appreciated, and it's that the way, not the part about the criminals turn their phones, like not that, or criminals put their phones in it, not that part, that's stupid. But the way he describes it is actually accurate for what the information they had at the time. Let me find it. Hold on. Okay, right here. This is the one thing I appreciate because this is accurate. So well, I'm not talking about the facts of the case or the timing. I'm talking about the way this is described, right? Phone stops reporting to the network right here. Can I highlight this? Let me highlight you here. Phone stops reporting to the network, which is consistent with either the phone being in an area without cellular coverage, the connection to the network is disabled, such as putting the phone in airplane mode, or that the phone is turned off. All those are options, and you wouldn't know which one it is until you get the extraction back, which of course had not happened at this time. This is accurate. What I appreciate is that it didn't just assume airplane mode or assume anything, right? But the reason they're saying stops reporting to the network is because that's all they can say at this point, is that it's not reporting to the network. That's all they can say without further information. So it's accurate languaging to say that. To give just another example, right? Let's just say that there's somebody who's missing, right? This is not really a great example. Well, until you can confirm that the person is some harm befell them, right? Or whatever, you say they're missing. I don't know. That's not a great example. Just what I'm saying is like, that's the most you can say without further information, right? Because for example, if the phone is in airplane mode, it stops reporting to the network. If the phone is powered off, it stops reporting to the network. If the phone's battery dies, it stops reporting to the network. If a cell phone's out of service, it stops reporting to the network. So you see what I mean? That's the only accurate way to describe all of those different potential situations. So that's why it says that in the PCA. So does that help? So if you want to direct me to a specific document, I mean, I've read them all, but like, because the context matters, right? And when the documents are written matters too, because one thing we still don't know yet is when they got the Celebrite report back. We don't know that yet. And that would make a big, big, big difference because it's like, there's a lot that would be unknown until that report comes back. So, okay, so what was I doing? But yeah, but anyway, I was saying that it was interesting that that Andrea Burkhart also said that about the phone being off. I'll have to find that so we can discuss it. But again, that wouldn't be known until the Celebrate comes back or whatever. Again, just thinking back to Carrie. Hopefully they did more than one. They ran more than one program on it, but you know what I mean? The phone extraction, let's just say. Okay, so email between Gamut and Mooney, contact for genealogy, I guess that's supposed to say. Arizona v. Mitchum opinion from Court of Appeals, more sealed letters. I'm going to zoom out here because it's different. Department of Justice, and another one there. Colorado v. Phillips. Well, now that's good that we're getting to see what the case law they were using. Okay. And then return of warrant. Oh, it's just Exhibit A. Okay. Oh, that has to do with the AT&T first warrant. Okay. Affidavit for search warrant re AT&T. Okay. I wasn't even looking at the right. Okay. So far in the right-hand column, all of this on the first page, this was all for Franks. And then on this one here, these were the different motions to suppress. Okay. And you can see it's much shorter, way more exhibits when it came to the Franks. Okay. And now motion to suppress repent. Oh boy. Oh my God. Okay. Pen, trap, and trace, people. All right, AT&T second warrant. Let's see. Return of search warrant, affidavit, receipt, inventory, and order. Pen trap and trace warrant. Exhibit C, AT&T form with warrant. Exhibit for search warrant, or sorry, affidavit for search warrant. Oh, none of that's that exciting. Dang it. And then here's for Lambsden Drive. Rust warrant, search warrant. Okay, fine. These are all standard. Fair. Okay. For the apartment. Okay. Still no mention of what type of cell phone it is. Affidavit for search warrant. January 9th. Huh. So, here's the thing. Let me see if I can find that. Wait, what year? Hold on. January 9th, 2023. Let me see something. What forensic lab did it say Moscow? Okay, hold on. So what's interesting, let me show you guys this. What's interesting is like when one would see this, one might think it's like, well, it could be anything, right? But the reason I was looking for this is because when you look here, the forensic lab, this is forensics as in digital forensics or whatever, right? So what I'm wondering, okay, let me look at this. Hold on. So because I'm wondering if we can get information from this as to when they finished the phone extraction, like I kept mentioning here. Okay. So on January 9th, I obtained a search warrant for data extraction from Brian. So I remember I've actually read this one before because I was laughing at the fact that it says Brian Koberger's phone with a capital P and doesn't say what kind. But on January 9th, 2023, obtained a search warrant for data extraction. So this would mean that that's when that process can begin. Obtained a search warrant for data extraction. Okay. It's redacted. Because I'm just wondering, is it going to have a date on here as to when there was a return? Okay. No, that's what they're allowed to. Dang it. Did you guys see a date? I think it's redacted out. Let me just take another look here. Okay, let me do another Google search here. Because I think the extractions can take time. Looks like well, it goes without saying, it depends on the volume, right? But like, it can take like an hour or two if you just have a small amount of data, but it could take much longer. Like this one says a phone had 192 gigs and it took 12 hours to open it. Huh. Let me see what you guys are saying in the chat. So, okay, well, so it looks like it might have been possible then, depending on how much information was on the phone, right? That they could have gotten it back the same day on January 9th. You know, does it have the timestamps? Let's see. 4:39 p.m. Oh, that's January 10th. So, okay, there's some, so there's also January 10th in here. So I wonder if they got it back the next day. So maybe as of January 10th, they would have had, not that the defense would have had it yet, you know, because they would have had to get it in discovery. And I don't even know if they had been appointed at that juncture yet. But, and this was put on, this was on the docket for March 7th. Let me see. Anyway, okay, well, we can keep that in mind. Okay. And then, okay, Apple. Reservation letter, subpoena certification email, affidavit for search warrant, return of search warrant. So like just as an example, you can see here, like the search warrant was 8/1 and then the return was 8/9. And then going back up to the phone, you just get the one date. So, okay. Anyway, thumb drive containing information from Apple. Amazon. Search warrant, search warrant, search warrant. Yeah. Subscriber information. Google warrant 1, 2, 3. Again, that's not that exciting. And then receipt and inventory. Oh, no, it can't be. Yeah, they can't because they have to have the physical phone to do the extraction, right? So, what I like in terms of the timeline, right? It's like, you know, they were relying on the cell towers and stuff like that, right? Whatever call detail records, you know, everything that we heard about very much, you know, a ton at the hearings. You know, they were relying on that in terms of for all these search warrants, right? Because they didn't have the person, they didn't have the phone. And it's like, once you get the phone, once you get the person and you get the phone, and then you get a search warrant for the phone, and then you can do an extraction on the phone, and then you get information from the phone, then there can be subsequent things that happen with that new information, right? And so that's why I am wondering, when we hear them talking about certain things being done at certain times, it's like, let's just say that they're talking about, how to explain this? Like, to me, the way that they talked about the timeline, right, in those hearings last week was as if at this juncture, they're still relying on the cell towers and shit, right? Which again, that's why this is why I'm asking the question, is because it's like, well, is it just that they are that good at dividing their brain up to where they're not adding in new information, like to where they're able to only reference the evidence that was used at that time? Like, obviously that's the job, right? But at the same time, if you do get information from a Lallyport extraction, say, that would have completely refuted what the state suggested in terms of the towers and where the phone was and everything like that, that would have come up by now. Like, that would have come up by now. And so the fact that, that's why, to me, the fact that like they haven't been relying on any new information gleaned from the Lallyport extraction is interesting. Because again, it's like, that would be normally a wealth of information, potentially, like, for, I mean, I guess usually it's going to be for one side or the other, right? You know, I think somebody asked a question, I'm trying to remember who it was. Somebody asked a question about, you know, because we were talking about Faraday bags, right? And like remote wiping. I mean, anything's possible. I mean, I know that there's, you know, I've heard that, you know, BK was supposed to specialize in like iCloud stuff or whatever. I mean, I don't know if that's been verified or confirmed. I'm just, you know, I don't know. I shouldn't even say it because I don't know if it's been verified or confirmed. But even if that's not the case, right? It's like, you know, we know there's an iCloud account, and apparently, you know, it would be similar with Google. Like, all you have to do is access it from a different device through your cloud account. We heard about that in testimony we watched from Murdoch, and how it sounds like it's actually pretty easy to do. So I don't know. But what I'm saying is, like, if like, just how wild it would be if like there just wasn't anything gleaned from that Lallyport extraction. Like, the data was just not there, right? Or like, I don't know, it's just interesting. What is DR? Yeah, so it's just like, everything that's been relied on for both parties in this case so far has completely been, you know, the contents of the cell phone have not even come up. It's just odd, right? Like, anything regarding the cell phone is simply has to do with the freaking towers and, you know, not reporting the network, which is like, do you guys see why I think that's odd? Is because, like, at that point in time, when that's all you have, that would make sense, right? Like, back in December of 2022. But once you've got more than that, for example, you've got the data from the cell phone after the extraction, it's like, the fact that that's what you're still talking about, like, it's just, it's like, did that not give either side anything? Like, it just is hard to fathom unless it was, you know, anyway. Okay, so Google warrant 3, email between Lawrence Mallory and Google. So I guess he did email Google, which is hilarious. Can you imagine Google getting that email? Hi, I'm Lawrence Mallory. I'm the Idaho Lally. Anyway, oh, that's the last page. Okay, so now let's look at what else we have, because I think there was some other filings. I think we already saw this one, because sometimes they get posted out of order, but just in case. Yeah, I think we saw that one already last night. And then he amended it, it looks like. Yeah, he amended it. Okay. Amended order extending deadlines to file motions. Interesting. Wait, huh? Is this not the exact same thing? Hold on. So here's this one. So it says February 24th, March 17th. Replies. Oh, this is probably a typo. Oh, you guys probably can't see that. Hold on. I wonder, so this would be probably a typo because this should be a later date, right? So because the replies, it would have, I bet that's what it is. Let's just see if that's what it is. Yep. Called it. There it is. See, March 17th and then March 24th. Yep. Yep. So that was Judge Hippler just accidentally he typed the date, the same date twice. He meant to type this. That's all it is. Okay. That's it. So this is interesting though. Wait, is this not that one? Hold on. Where'd it go? Who was it that said that something about this? Was it you? Somebody said that this gave them the impression that Judge Hippler was going to grant the motion for Frank's hearing. Was that you, Tonka? Does anybody remember like that? For example, that this filing, like, am I looking like in other words, what I remember somebody saying like one of the new filings pointed in the direction that he was going to grant that. So, I mean, what I will just say is what this is, right? I know that oftentimes it's like we see pleadings, right? And it's for something upcoming. What this is, and this is what I said just from reading the title when it was on the case summary, but hadn't been posted, right? Just from reading, again, right here, notice of filing of stipulated exhibits for motions press motion. Like, I don't know if people got confused by this title or whatever, but like literally this is normal. Like, you know, when they had these hearings last week, they referenced a lot of exhibits, and there may have been exhibits that they maybe weren't sure if they were going to use them or not or whatever, right? And all this is just because normally this list would have been already like, I guess, published. So like basically but everything was like the lists were sealed, right? So all this is they stipulated. Let me look and see. Actually, hold on. So there's a stipulated motion to seal the witness list. So, like, essentially, obviously, the exhibits are still sealed. It's just that they decided this is just the list, right? And like, yeah, this is not anything out of the ordinary that like both parties stipulated that these were the exhibits that were used. Here's the list of them that we used and we relied upon. And these were the exhibits that were referenced, you know, when we heard them mention these different things. So, Tonka, did you hear my question, or did you know, was it you or was it somebody else, do you know, that was saying tonight about how one of the new court filings had pointed in like the possibility of the Frank's hearing? So, because I mean, maybe I'm missing something. But yeah, this has to go on the record anyway, like what they used at that hearing, regardless of whether it's granted or not, right? Like that's just, so yeah, so like I'll just read it. Like, by and through attorney's record, stipulation by the state hereby files lists of all exhibits admitted by stipulation during the various motions to suppress and motion for Frank's hearing held on January 23rd and 24th. That's, yeah. So I feel bad for anyone who thought it meant that there was like another motion for Frank's coming or something or whatever. I mean, I think that some of them, like the most interesting things to me here are like we learned about the like the communications here, like the people emailing, and then like the Tom Slavinsky, right? That we didn't have that name before. And then the other thing I found especially interesting, well, yeah, there's the Lallyport report again. There it is. And then the letters back and forth between the prosecuting office and the FBI. Like that's really interesting to me right here. And then of course this one also confirms the fibers with the hair, no connection. You know, we hadn't seen that in writing yet until now that I can recall. Those are some of the most interesting things. And again, oh, and then this, yeah, sealed letters between count. Oh, and then the other thing that was the most interesting too, the grand jury transcripts. I just have never, I can't believe that. I can't believe that. They got, where was that? Here. Blows my mind. I'm like, that's always denied. Wow. Like, I mean, yeah, I'm just looking at, I mean, because the thing is like that standard is this highest, right? Like that's like the strictest standard for breaking the secrecy. Like that's wild. They had to show what the defense had to show to get that it would be insane. I don't know that we'll ever get to know what they had to show to get that, because that could then indicate what was in the transcript, but like that is crazy that they were able to do that. Wow. When did they, let me take a look. When did they make a motion to, let me see. Let's see. So that was in December of 2023. So Judge made that call. Of course, it gives no information. It's just like according to the rule. Oh, interesting. Interesting. So they gave it to the state. If it's funny, the font is different. Oh, that's because it's from, yeah, Teton County. Right. Okay. So then let me see. Trying to see when the defense would have gotten it. So the state got it, and then in May they made a motion to file the records under seal. Just trying to. Why won't it let me show this tab? Yeah, so I just wanted to show you guys what I'm looking at here. I'm looking at the history with the grand jury here. So so the state got the records, then they made a motion to file them under seal. Still in May of 2023. Motion to make available all the record of all proceedings of the grand jury. What? How? 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 So that's for the defense. A transcript of the initial seating of the grand jury, a verbatim transcript. Wow. 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 So this is what I was looking for. How the hell did they pull this off? This is what I was looking for. What did they say? How did this happen? I'm just flabbergasted. So this is what they're asking for. And they're just citing the Idaho criminal rule. They're requesting 10 minutes for hearing on this matter. Wow. They want to know what the grand jury relied on. And they did end up having a hearing, notice of hearing. Okay. And then the court took judicial notice of it. Okay. Right. So, okay. So the reason they were requesting it, right? Okay, now I remember, is because they were going to make these motions to dismiss the indictment on grounds of biased grand jury right here. You guys remember this from back in the day? Wow, this feels like a lifetime ago. That's how they must have gotten, that's how they did that. Wow. Also, I'm glad I saw this because we were talking about this last night, and let me go ahead and, so I don't forget, I'm going to go ahead and pull those up. Okay. The other thing I want to do next time we do BK is, what wasn't this one? Is look over the notice of alibi, because I was thinking about this. I was thinking there might be some interesting information there that will help us with our mapping, or me rather, with what I've been working on with that. So, okay. Anyway, so that's one thing we will do next time, because I've been trying to go back and update those maps and add in the Brett Payne exhibits. Response to this. So yeah, a lot going on right now, huh? So anyway, but that's all I got for this one, guys. We covered a lot today, like a whole ton. Right. Well, but the reason, I guess what I was asking isn't like, the reason I was asking is because there would be something they were going to do with the transcript, right? And I'd forgotten that they had made several different motions based on the grand jury. Like that was the foundation for several different things, like motion to dismiss the indictment, and then there was that came up in other filings as well. Jay Logston loves to bring it back to the grand jury, so that's yeah. Yeah, we covered a whole ton. So so we'll be on the lookout for other court filings, as always, with this and with Karen Reed. But yeah, I believe tomorrow we're doing Adelson's. I can't remember, but anyway, I have things scheduled, but yeah, I think that's it for this one, guys. Yeah, love getting to see y'all as always. Y'all are awesome. Squirrel Crew for life. And yeah, thanks everybody for being here, and see you guys next time.